Sir, advocates are requested to observe 2 minutes silence by 11 o'clock, sir.
Lords, kind leave to mention, my lords, in list number 2, item number 1, is that, my lords, matter, sorry, my lords, it's that matter relating to the transgender issue. My lords, could it be had on Thursday, my lords? The respondent has moved or even tomorrow. Lords. No, my lords. In fact, now, my lords, at that stage, what had happened was there was an interim order, my lords, directing admission, which was, my lords, complied with. But on merits, my lords, our case was that there's no basis, my lords, to admit on a transgender quota. And, my lords, that so far as the petition, that writ petitioner had, my lords, competed in the examination, the petitioner had not met the qualificatory requirements. So our stance is, my lords, that final judgment today directing admission, despite the fact that they don't meet the eligibility, is wrong. My lords,
Lords, in 10 days, the admission process will be completed and the first session will begin on July 1st. July 1st. That
Lords,
is
in
why.
fact, very well. Lordships may have it next week, Lords. In
Lords.
fact, when your Lordships took it up in the previous occasion, a submission was made orally that enforcement would not be sought. Very well.
Pardon, Milord? July 1st. Milords, I have moved an IA for directions. I have moved an IA for directions if
I'll file my reply to that, Lords. It's been
that the admission process be completed because thank
Please,
you.
Lords. Deeply obliged. Appellate. Obliged.
My lord, two fresh contempt matter, my lord. Matter pertains to pension. Direction is to consider my case for pension, my lord. Even after 8 weeks, my lord, they have not considered.
Let's,
Fresh contempt, my lord.
let's contempt matter
Please,
pertaining.
my lord.
Please.
With the Lordship's permission.
Lordship, this is a
With the Lordship's
matter
permission.
for restoration of the
Lordships kindly.
List ones.
Please.
Lordship, this memo is to for
With the Lordship's. With the Lordship's permission, serial number 71 in list 1. Please.
Lordship, this is for restoration of the case. Last time, the Lordship was pleased to dismiss the case for not complying the office objections. But unfortunately, I was having high BP and I was forced to take bed rest for 2 months, almost 2 months. As per doctors. No, I'm filing a memo. I have already filed an application, Lordship.
Where is the application?
It has already been filed with the registry, Lordship.
Want to get that application listed?
Yes, Lordship.
For recall?
Yes, Lordship.
Please.
Sir, right here, names, your names.
Please, my lords. I'm a school, my lords. I'm being put out of the possession and it is a contempt case. I am a school, my lords. I'm being put out of the possession and we have initiated a contempt proceedings against the respondents, my lord. May be taken up on against.
Kindly, my lord. A state appeal, my lord. There's a contempt that has been filed and scheduled for listing on Wednesday, my lord. Matter relates to the writ petitioner that sought for exemption from stamp duty, which the government has rejected, my lord. There's a financial implication. The direction of the writ petition is to consider the representation seeking stamp duty exemption, my lord. Stand of the government. Yes, my lord. Contempt is on Wednesday, my lord. Done, my lord. My lord. before your lordship. 2025 contempt.
My lords, my plane got rejected for non-compliances of section 80, my lord. My plane got rejected because of non-compliances of section 80, my lord. I made ROC as a party and notice has been not served for the ROC, my lord. So the plane got rejected, my lord. The urgency is, my lord, now I am a commercial appeal, my lord. The urgency is, my lord, I have invested more than 6 crores, my lord. And now they are not making me as a partner, my lord. Now the thing is, they are alienating the suit schedule property for the third parties, my lord. My lord,
The order passed by the trial court.
on Feb of this,
Why are you coming so late?
my lord, I have mentioned in the last date, my lord. Last April, my lord. On 23 of 25, my lord.
The objection
Yeah, yes, my lord.
Lordship, list some.
or any other mentioning?
Yes, my lords.
Tell us.
My lords, in this matter, KDB has allotted lands exclusive to my brother, my lords. Even though it is based on a collusive compromise decree and petition was dismissed, my lords. We have filed writ appeal. They're trying to construct on the land, my lords. We filed writ appeal.
Have they allotted?
Yes, my lords. My lords, allotment was made in September last year, my lords.
When was the order passed by the legislature?
My lords, January, my lords. January.
Yes, ma'am, tell us.
My lord, it is a matter of civil contempt. We have seek this honorable court for non-compliance of the trial court order by the investigation officer. I am the accused number.
Write your name.
I have written it.
My lords, may I please mention?
On the
This is
top.
also a civil contempt matter. I'd filed a memo for posting on the 3rd of June. My lords were kind enough to give me the date on the 16th of June. But by oversight, it was called on the 4th. That is what shows on the website, and it is adjourned to July. I'm requesting for.
ये इंडिया के हमको 43 प्रॉपर्टीज करना है ये है तो अभी स्टक का तो ये कि
Kind enough to give me a date saying 16th of June, it may be heard. But the very next day, it was called off and adjourned as and marked as petitioner absent. So please.
On the date now?
Yes, please, my lords.
Yes.
Please, my lords. Serial number 71 in list 1. 71 in list 1. I'm for the petitioner. I have some personal inconvenience today. I'm just requesting. The state is the other side.
Have any objections?
No, only 71.
The request of counsel for the petitioner.
I had a benefit of an interim order that may be extended. I had a benefit of an interim order that may be extended. I'm very grateful.
My lord, serial number.
18
Serial number
A
77 in list 1.
77. Yes.
My lords, pray for a short accommodation, my lords, some inconvenience.
Other side, and who are there?
The government and the BDO, your lordship.
77.
Notice, lordship, notice has not been issued yet, your lordship.
The request of counsel for the applicant. Adjourned to
12-8. 12-8.
Lordship, list one, serial number 53, please, my lordship. A request for 2 weeks' time, my lordship. I have informed the other side.
You have to inform the other side. Is anyone appearing the other
The
side?
notice is not served yet, my lord. It's for admission.
You said 53.
53, please, my lordship. A request for 2 weeks' time, my lordship.
You are appearing the request of the petitioner.
Lords,
13-8.
Lords, list number 150, serial number 56, Lords. And for the appellant, Lords. Request for 1 week's time.
Who is the other side?
You have informed the other side, Lords.
Huh?
You have informed the other side, Lords.
You have informed?
Yes.
Counsel for the other side seeks an adjournment, stating that he has informed the counsel for the other side.
13-8.
Much obliged.
The Lord's
list one, serial number 51 for the appellant.
Which number?
51, list one. The central government is on the other side. We're seeking a short accommodation.
Who is the other side?
I appear to the government, my lord, this requires a detailed hearing.
Twentieth August.
It's list one, serial number 37. Maybe memo for withdrawal is filed, members may be dismissed as having become infructuous.
Who is the other side?
Its notice is not issued. It's filed, man. It's already filed. Please. The cause list is also reflecting the same.
I him on 13/6/25, which reads as in which the appeal is dismissed and in view of the memo, the appeal is
Obliged.
My lord, serial number 65 in the first list, my lord, I appear for the respondent. I have informed the, no, my lord, 65, my lord. I have informed the appellant and they're okay with it, my lord. 65, my lord. Respondent Kevita, my lord.
Appellant in this case, my lordships. A date may be fixed.
Yes, my lord.
Appellant, my lordships.
which is not opposed.
Yes, my lordships. A date may be fixed, my lordships.
18/8.
A shorter date, my lordships.
Yes, next.
My lord, serial number 10 in first list, my lord. Serial number 10 in first list, my lord. 10 in first list, my lord. My lord, I appear for 10, my lord, 10, my lord. My lord, arguing counsel is out of station due to health issues, my lord. I mean, serial number 10, my lord. Contempt, my lord, they have filed. My lord,
Private response.
in
This will not say. No, serial number 10 is the private respondent. No, Mr. Dharampal, basically a private dispute, not concerning state. Yes, my lord, Sanumanta Reddy G reflected. Concerning the state officer? No, my lord. Just wait.
please, my lord.
Your lordship's leave, serial number 57. I'm for the appellant in 57.1.
Yes.
I've informed Mr. Sangamesh, learned counsel, for the complainant and respondent.
Just say that the
Appellant.
in intervene 1 month, because he said that he has informed Mr. Sangamesh RP.
14/8.
Grateful.
Serial number 1. Shravan Lokre, serial number 1.
Case, my lord, office, there are two objections which have been complied last time. Service of copy to the other side which they have received, and they have appeared also.
I received a copy. I need a week's time to file my objection to the stay application, my lord.
This will be for the respondent. He said he's allowed how much time?
2 days or 3 days time. my lord.
We'll have it in first week.
But let them not precipitate the matter because serious objections are raised. Questions of bias is also questioned. Learned judge doesn't consider anything, my lord.
Objections already.
Now that the
I will file it tomorrow only. It may be taken up on day after tomorrow
matter is
also.
also settled by the lordship. What the issue? Right? The issue is regarding the fact that I have put up construction, completed the construction. When I asked them back the refundable security deposit which I have paid them, they raised new issues belatedly, and that has been approved by the, in the issue number 1 itself. Claim is for money, my lord.
Yes, my lord.
So this is basically under 34.
Yes, my lord. 34 is dismissed, my lord.
Your claim was rejected. Both of us challenged it in the 34 proceedings. So, but he has not come. You were the claimant? Yes, yes. Rejected complete? Yes, sir. Not rejected, partly considered, partly allowed. So vague. How much of your claim was allowed? Only about 10% of it, which was adjusted towards their claim, and I was directed to pay. We'll see. Not kindly fix the dates. They wanted only 2 days. 2 days.
17-7.
Please.
Yes. Appear for the appellant. My lord, in this case,
Dispensation in there, in
You moved 2 memos. One in the registry on the 3rd of June. That was the first one. You moved 1 memo in the registry also. They asked for posting. They said after scrutiny you have to mention that the scrutiny objects are removed and posted. So now there is a date of 3rd of July. Yes, ma'am. So you appear on that day. On the 3rd of July. Okay. Yes.
yes, my lord.
Serial number 2.
My lord, in this case, my lord, there were initially 4 objections. My lord, only one objection remains, that is, my lord, regarding payment of deficit court fee. My lord, right now I am paying it. My lord, this may be. Can I just make one request, my lord? An identical case, my lord, is listed at serial number 45 today. So both may be heard together, my lord. Seniority issue.
Lord, this is
my
not
lord, long-
seniority issue, my lord. My lord will remember case of a junior engineer who graduated, my lord. They will be not transferred to the cadre of AE, but my lord,
my lord, today, my lord. They are
but
listed-
today 45, my lord.
No, no.
There
no.
are other 3 matters. Kodi.
My lord, your
There are
lordship-
other 2 appeals, my lord. No, yet to come before the court.
My lord, your lordship are asking about that KPTCL. Yes. My lord, exactly. In that KPTCL matter, my lord, they are listed, my lord, in court hall number 3 today itself.
My lord,
Where, my lord?
KPTCL it is different, my lord.
No, no, my
Entirely
lord.
different. KPTCL is concerned, my lord, only absorption by transfer. Here is a case, my lord. By transfer, junior engineer who will be graduated, my lord, 4-year service should be considered prior to his appointment or not? Is the question.
This is Power Corporation.
Yes. Both are different, my lord.
Lord, these are the generating company, KPC. That is the transmission company.
No, my lord. Issue is not the same. That is why, my lord. Only KPTCL filed
Lord,
appeal. Here, 1 minute.
Yes.
But here, KPCL has not filed appeal. There, Lord, KPTCL has filed appeal. In that case, here, Lord, private parties are coming to Lord here. They are enjoying their direct reports. They are enjoying. Court never disturbed their position. Court just said you review, undertake a review.
Yes, my lord. Yes, my lord. Certainly, certainly. Because, my lord, can I just? Very well, my lord. Please.
My lord, may I make an appeal to your lordship? There are other 2 appeals. Say common order. Not 45, my lord. There are other 2 appeals. All together may be taken together.
Grateful to.
Serial number 3.
Represent the appellants in the matter, my lord. There are certain office objections which I will clear it, my lord. Before that, I have one submission. This is appeal directed against an application filed by me for an extension of interim order. That interim order, my lord, Lord, that page 83, my lord, is the interim order granted to me by the trial court.
My lords, what has happened in this matter is it's a section 9 proceeding. Both have argued on the merits. Now the presiding officer has changed. The matter is coming up before the trial court on the 23rd, my lords. This petition may be disposed of, giving a direction to the trial court judge to consider the main application finally, because both have in fact previously argued it. My lords, what happened
May I just
was
make the
an
submission,
interim.
please?
An ex parte interim order was granted in favor of the appellant. Subsequently, it was granted on a day-to-day basis. They failed to extend the interim order. Because they failed to extend the interim order, the appellants, they did not prefer an application on the hearing date seeking extension of that interim order. Yes, my lords, because the interim order was granted only till the next hearing date. Yes, the court could have continued it. It did not. What happened was, because they did not file that application seeking extension of interim order, the trial court was of the opinion that it should have been done.
Where is the return that every time they file an application?
My lords, if my lords may please see the impugned order. The learned trial court, my lords, has relied on certain decisions. And what? Yes, my lords, I agree. That is why my submission is, let their interim order continue for now. On 23rd, let the matter be disposed of finally. Yes, my lords.
Lord, I may comply during the course of the day, my lord. Lord, there were some corrections which had to be made with respect to the provision of the interim application and some page numbers, my lord. I'll comply during the day, my lord. I paid the court fee. If required, my lord, I will.
What are the objections?
Lord, first objection was that, my lord, the application filed, the interim, stay application, that was not under the right provision, and the court fee had to be paid. Court fee is made good. Court fee is made good, my lord. Thereafter, only the interim order was granted, my lord. 200 rupees, my lord, on 20th of May. Only thereafter, the interim order was granted. Okay, no.
There are four objections which have been notified by the registry which includes based on the report as well. Also for the current that reviewed before us, seat number 12191, 2025 2026. So that he has paid the full fee of rupees 200.
One minute silence for the matters. That is what I was informed, my lord. If it needs to be made good, I will, my lord. During the course of the day, I'll make it good.
We'll just pass over.
Please.
Serial number 4.
I am permitted to appear for the appellant.
Going for the respondent
Because
statement.
last occasion, there was a direction by this honorable court.
My lord, to carry out an inspection and submit a report, my lord, regarding the existence of a road, my lord. The inspection has been carried out. Report has been received, my lord. It's in the vernacular language. I will get it translated and filed, my lord. I can furnish it straight away, my lord. Please. Please, my lord, I will do that. I have just received the report.
Also for the respondent states that the survey as was directed.
20th.
25, 2025.
20th May. Yes.
And that he has carried out. He states he has also received the report.
Please.
And he shall get the same translated and file it before the court. Then give a copy to the council for the petition.
Very well.
So the sale be done within a period of 2 weeks. They say that respondent 4 to 6 are still unserved.
Yes.
And wish to be issued for service on respondent 4 to 6.
My lords, in respect of half subjection, my lords, I will not press the IA, my lords, there is no delay. My lords, IA for delay, my lords, there is no delay in filing the appeal. I will not press that application. No, that officer, no. Much only.
Interim order, status quo.
12-8. Serial number 5, Shiva Prakash.
My lords, status quo is there. My lords, to be maintained, my lords.
There's an order already.
Lords, there is no tilde. Much only.
Lord, I represent.
Shiva Prakash.
Lord, in this matter, petitioner number 1 is passed away, my lord. I will file necessary application.
Lord, may I make one submission? Your Lordship permits me. This is a PAL, wherein petition number 1 is read, we have reported death. Now petition number 2 is the only person who is prosecuting it. Who is prosecuting as on now? Question of bringing LRs does not arise in respect of a PAL. But what has happened is, it's a case where the petitioners are seeking for a direction to maintain the lands or Goma lands. These lands have been acquired by KIDB long back. That acquisition has become final. And we have been allotted land also, Millard, by paying substantial monies. I represent respond number 11, Millard. What is happening is that because of this particular pendency of the writ petition, even though I have parted with about more than 13 crores of rupees long back, we are not able to get the property to our hands. Possession is not being given. Let the matter be heard, my Lordship may kindly fix a date.
For the villagers, man. No, petitioner.
Yes, ma'am.
One has died. Please. Please, ma'am.
Not an individual grievance.
Yes, ma'am. Please, ma'am.
We only record petition number 1 has expired.
Please, ma'am.
And you will pursue this petition on behalf of petition number 2.
Please, ma'am.
Okay?
Yes, ma'am.
File the amended memo of ours.
Please, ma'am. 1 week.
Deletions had taken place.
Please, ma'am.
A date may kindly be fixed, Millard. What is happening? Yes, ma'am. Yes, ma'am.
We have been informed that petition number 1 is not expired. This for the petitioner states as petition number 2. The petition shall be prosecuted on behalf of the petitioner number 2, who shall be the sole petitioner henceforth.
Please, ma'am.
The amended memo of ours is defied within 2 weeks.
A date may kindly be fixed, Millard. Because 2019 matter.
11-8.
Obliged.
Serial number 6. Serial number 6.
For the petition, my lords. There is an office objection as to the maintainability of the writ petition, my lords. There are a batch of writ petitions wherein an order was challenged, wherein a patta land was converted, decided as forest land. Subsequently, one, my lords, annexure K, my lords. Lords, may kindly 27/6/2022 order passed by this bench, my lords, wherein it has been stated clearly, my lords, there are batch of writ petitions wherein only one writ petition was disposed of, my lords, which was affecting all other parties. Seeking review of order dated 13/3/2020 in the WP number 29328 of 18 minutes. Page 59 minutes. Yes, my lords, because I am also an aggrieved party. My lords, it clearly comes in line with the judgment of Honorable Apex Court in Shivdev Singh versus State of Punjab, wherein it states, my lords, when a party, person is not made a party, and by way of a judgment, my lords. Yes, my lords. review in the form of writ petition is maintainable, my lords. My lords, may I place the judgment, my lords? May I refer to para 10, my lords? My lords,
Maybe right, the challenge will be a higher court or review for the same court. See your prayer.
my lords,
When you nomenclature it as a repetition.
my lords, may I please read para 10, my lords? The other contention of Mr. So-and-so pertains to the second order of Justice so-and-so, which in effect reviews his prior order. Learned counsel contends that Article 226 of the Constitution does not confer any power on the High Court to review its own order, and therefore the second order of Justice so-and-so was without jurisdiction. It is sufficient to say that there is nothing in Article 226 of the Constitution to preclude a High Court from exercising the power of review, which inheres in every court of plenary jurisdiction, to prevent miscarriage of justice or to correct grave and palpable errors committed by it. My lords, in this order, my lords, it covers the entire lands, my lords. My lords, may I make some research, my lords? I will come before your lordships, my lords. A date may be given, my lords. Kindly, my lords. Subsequent to this judgment, yes, my lords.
That's a more appropriate phrase.
Review in the form under 226, my lords, because I was not a party to this. Yes, my lords.
It's a review in the sense. If you want to, that it should be treated as a review, you will say so. Then it should go, at least one of the judge call is there.
Kindly, my lords.
That's can be thought of.
My lords, I will. Kindly, my lords, kindly.
19-8,
Great, sir, my lords.
serial number 7.
Yes.
Lord, there was a notice to the appellant, my lord, on last occasion. There was an order issuing notice to the appellant because the counsel on record had become a government advocate. Therefore, court had issued notice. Appellant's notice was served. Sarva Vidya.
We have been informed that notice on the appellants issued on 19/2/2025 is still unanswered. The application notice be issued to the appellants return to law.
18-8, serial number 8. Serial number 8.
8, my lord. My lord, appeal is preferred by corporation, my lord. I appear for corporation, BBMP. 1542 is preferred by corporation, my lord, challenging the order of learned single judge. They have filed a complaint, contempt.
Appeal is connected matter is
Lordships may
appeal.
kindly see
Connected
in
matter is
page
the appeal that have been filed.
11th October 22. Please, my lord. Your Lordships, it's come on office objection. I have served the copy on the
Copy
complainant.
I received. Copy has been received.
Lordships may kindly fix a date. We'll argue the matter. Yes, my lord. The only objection is that I have not served the copy. That is, he's acknowledged that. No.
14/8.
That's some earlier date, July. Yes. So the last 25 years, they are waiting for execution of sale deed by the others.
4/8.
Obliged.
Serial number 9. AP Mahesh.
The first matter, my lord, I appear for the petitioner. Your lordship may kindly grant 2 days, my lord. I'll furnish the process to issue notice to the accused number 1, my lord, in first matter.
19/8.
9.2, my lord, is state's appeal.
9.1.
9.2 is.
I'm for the appellant in 9.1, my lord. In respect of respond number 4, my lord, I've served through hand, my lord. I filed a memo. Respond number 4, my lord.
Respondent number 4 in the second matter, my lord, I undertake to file wakalat for him because he is the petitioner in the complaint contempt matter. My lord.
For whom you will file wakalat?
Respondent number 4 in second matter, my lord, in writ appeal.
So and so appears for respondent number 4.
Yes.
Who though unserved, states that he shall accept notice for respondent number 4 and file wakalat.
Served by hand.
Served.
Writ appeal 183. Huh?
Yeah.
Same order may also be passed in 9.2 with regard.
Similarly, he shall also file wakalat for some common respondent R4.
Respondent number 1, my lord, in third matter, respondent number 1.
No, in 9.2,
4,
are you appearing for respondent number 4?
Yes, my lord. Second matter, respondent number 4. Third matter, respondent number 1. AC Ananthaswamy.
Different person.
Because in the third matter, I have been made as respondent number 1. My lord.
You are 1, so you are appearing.
Yes. AC Ananthaswamy, yes.
Who is respondent number 4 in item number 3, 9.2?
I am not responding. I am not representing.
We have taken hand summons.
Just say that let fresh notice be issued to respondent number.
Memo has been filed, serving the hand summons.
Just
That
show
may be
that,
treated
ma'am.
as sufficient.
Item number 1 says memo.
My lord.
Just say that in writ appeal 475/24, a memo has been filed by the counsel for the appellant, having served respondent number 4 in this appeal. We find there is no appearance for the respondent number 4 in this appeal, despite service.
Yes. My lord, insofar as 3 is concerned, my lord, furnishing of process fee, insofar as R7, it's a land tribunal, my lord, a formal party, so notice may be dispensed with to R7.
R7 in item number
9.2.
Notice to respondent number 7 being the land tribunal is dispensed with.
Insofar as respondent number 2, my lord, R1 may be directed to give us the details of the legal representatives.
In which matter?
My lord,
9.2 itself.
My lord,
4, non-taking of steps in respect of deceased R2.
my lord, in 9.1, if I may submit, my lord, respond number 5 is deceased, my lord. On the last date, my lord, I had submitted that I would file a memo. Memo is ready, my lord. No further.
Now this R5 and R2 are same. R2 in 4.475.
We'll collect the details and take steps to bring
The same
your
person, my lord.
Huh?
It's the same person, my lord. R5 in my appeal.
Give the details to him.
My lord, my.
Stop. We have been informed that R2 in WA 183/24, who was also the
R5 in 183 is R2 in 475.
Okay. R5, not R2. R5 in 183, who is the respondent number 2 in 475/24, and has expired.
Yes, ma'am.
The details of the legal representatives be given to the counsel appearing for the appellant in 475.
My lord, if I may make a submission, I was to file a memo, my lord, before the
Do one
learned,
thing, just give a copy to them.
before learned single judge notice was dispensed with, my lord, and he has no right.
But the last sentence, ma'am, just say that counsel to take steps to bring the LRs of respondent number 5 in 183 and respondent number 2 in 475. Deceased respondent, just say deceased respondent.
My lord, then I may be permitted to file the memo on the count.
File it.
Yes.
Who is stopping you? File it. List on.
Number 10.
Lord, I beg to appear for the alleged contempt now. It was for compliance, my lord. We have filed a memo of compliance.
Just say at the request of counsel for the petitioner adjourn to.
No date may be.
58. 58. Serial number 11. Mahesh Uppi.
Of the complaint. Lord, the then president and other directors of a cooperative society misappropriated funds of the society, Lord. As a result, depositors have lost, Lord, 150 crores of amount, Lord, which were deposited in the society. The complainant, Lord, which has also one of the depositor, has made a representation to the government to initiate proceedings under KPID Act. Lord, no action was taken. Then writ petition was filed. In the writ petition, there was an undertaking that, Lord, they will take action. Time was given for a period of within 6 months, they have to do it. They have
Compliance
not done
affidavit's been done, my lords. Page 6 of the compliance affidavit. Section.
Give me
Copy, you got the copy?
It is given, my lord. Now, my lord, action is taken only against president. Other directors, my lord, who have swallowed the money, my lord, to the tune of, my lord, 33 crores as per the audit report.
You file a response to your complaint?
Yes, my lord. I have filed objection, my lord.
Where is that?
Lord, that was filed on, my lord, 9th of April.
Yeah, we have.
In that, my lord,
May I make this submission, my lords? KPID Act stipulates that government is empowered to identify the properties, and those properties as a first step stands vested with the government. So once the representation was given, we didn't consider the representation, mandamus was issued. So as a first step in 2024, we identified 28 immovable properties. Notification under section 3 is issued, my lords. These are properties with prima facie we were able to identify. Now in the reply they say consequential action under 5 and 6 has to follow, my lords.
Not only
so that will also follow. Competent authority is to be appointed. First step is section 3, then the competent authority will also be appointed as such, my lords. Now I have also sought instructions whether competent authority has been. So what will competent authority do? Competent authority has to then go before the special court, which is situated in Bangalore. For the entire Karnataka state, Bangalore is the only special court, my lords. First step, we take the vesting. Then we approach the competent court and take measures under section 6. That is to get the confirmation from the competent court to liquidate the properties, my lords. And what about his grievance with regard to the other members of the society? Other members of the society, we are unable to bring out the information that concretely what properties they have misappropriated, my lords. There's a general assertion that. But why don't you convey to him your reasons not to implead that? You see, where do you say so?
Lord, in my additional reply, Lord, I have produced document, Lord, representation. In the next page, Lord, I have given the details of the amount the remaining directors, Lord, misappropriated, Lord.
No.
Last page.
Where do you in the objections?
Yes, Lord.
To the compliance affidavit say?
Yes.
Where do you say about the others?
Yes, Lord.
Para 6, it's a general government at page 2 of their reply, my lords, what's been filed to our.
Lord, para 4, Lord. Para 4, 5. Even after 1 year of passing of the above said order, the accused have not passed any order. Hence, the complainant filed the above contempt petition. Now, during pendency of the above contempt petition, the accused issued notification under the KPID Act attaching only some of the properties of the then president. The complaint by a letter dated 28.
And your representation.
Yes. the second representation with the objections to the complaints.
Now, there are two representations, 9/11 and 2012-22. He must have named others also.
Others, generally, they have named the main president along with the other directors. What we are able to bring out in the investigation is this
We'll
initial
see
28
that.
properties.
Where are your representations?
My lord, you will ask me, in the objections to the complaints, my lord, I have produced that second representation, my lord, dated 28/3/24, my lord.
Not 28/3/24. The court refers to paragraph 2 at page 18.
That is, my lord, in the writ petition. Now, my lord, in the objections to the complaints, my lord.
You can't go on qualifying it one after the other.
Yes, my lord.
Did you say so in 9/11 and 2012?
Yes, my lord, I have stated that.
Where are those? Where are those representations?
My lord, I produced that, those representations. But in the objection, my lord, I have stated that, my lord.
We have seen that. That's only in 2024. Much after the court had passed the order.
My lord, I produced that 9/11 and 2011. That was
Did
produced.
you say
Yes,
in
ma'am.
these two representations,
Yes, ma'am.
9/11 and 2012, about what you have said in page 6 of your representation of 24, you have named the persons, directors, and the outstanding.
Lord, I have stated that other directors, my lord, other office bearers of the society, my lord.
Come to your representation with the objection, last page.
Objection to the contract.
Yes,
Complaint.
see page 6 of that.
Yes,
You have given the names, 7 names.
yes, my lord.
Are you referring to these people?
Yes, yes, my lord.
So did you name these people in the earlier representation?
Lord, I have not named them, Lord. I have stated directors, office bearers. my lord.
Then you must say so, no?
My lords.
You must say so. Though he said a general reference, directors, now he is qualifying by this.
This is the audit report, my lords. May 2024. Notification. 23/1/24. For approval of liquidation, but from directors also. He's given the name. He has to make an investigation into that.
Now tell us one thing. When they made a earlier representation, you say it was a general allegation.
I would say the whole issue is the diversion of the funds from the said society. So we'll have to identify everybody where the diversion has happened, irrespective whether he states or so. So in the prima facie investigation, what we undertook, which is also coming out in page 7 of our order of attachment, we are specifically told, my lords, if I may able to just take the 2 paragraphs as such, page 7 of the compliance affidavit, my lords. That's the second page of the notification issued by the government. Now, therefore, in exercise of the powers conferred by subsection 2 of section 3 of Karnataka Protection of Interest of Depositors in Financial Establishments Act 2004, the government under the circumstances state above, having satisfied that in order to protect the interest of depositors, it is necessary to attach the movable and immovable property believed to belong to Kamalakshi such and such Sangha Udupi. Therefore, the government. So it's not what we are able to identify is the initial 28 properties. So the investigation happens further also as such, my lords. This is the initial step what we have taken. So it's not that we are confined to a person or the other person. So as a general investigation, wherever we have found diversion, these 28 properties stand out. So as an initial step, we have identified. If they are able to cooperate and give us further details, we'll also go into that.
So this representation, this memo-
Representation, we have started the process. Their complaint was we have not at all started any process under KPID Act at all, my lords.
This letter of 28/3/24,
My lords,
where they give the individuals' names also, will you look into them?
we are bound to look into the same, my lords.
Okay, then what will you do after looking at them?
If we are able to find out those properties, we have to attach the same. If we are able to get evidence that the money by which those properties stand in those individuals' name have come out from this credit society, we are bound to attach the same. We are empowered under the act to attach the
Now,
same.
since you have the benefit of these names, will you look into them?
We are bound to look into the same, my lord.
So we will record that, and whatever you take action, you place an additional affidavit.
Further action from what notifications been done, we'll place the additional affidavit as of 2025. What's the status of the same, my
Go
lord?
to that notification at 7.
Very much, my lords. This is dated 21/3/2024. Post 21st of March 2024. I'll also by means of additional affidavit state what's the present status as such, my lord.
One more submission, Lord. Now, Lord, on 21/3/24, Lord, some of the properties of the president are attached. As per section 5, Lord, immediately they have to appoint competent authority. And within 30 days of this notification, that is 21/3/24, Lord, he has to file an application before the district court for confirmation of attachment. Even to this time, Lord, there is no material to show that competent authority is appointed. If he is appointed, he has filed any application or not. Proceedings are pending before district court Udupi, not Bangalore, Lord. Nothing is done.
Telephonically, I verified on the sets aspect, my lords, something which I want to bring it. First, the AC was appointed in the sense, my lords. Then there was a change in the official. I'm just orally what communication I've received, I'm bringing to the notice of the court. So there was a change in the person designator who was appointed, my lords. So I asked for those details. That's the reason I'm telling. Post 21st of March,
You file an additional affidavit.
bringing out the developments post the notification issue. Very much, my lords.
21/3/24. You must also consider
Whether any property stand in respect of the other directors, my lords.
other direct, you'll consider this response he has filed to your,
We'll answer the
compliance
response
affidavit.
what's been filed as such.
Just say that we have heard the counsel for the parties for some time. Mr. Naveen Chandrasekhar, learned counsel appearing for the respondent, states that he shall file an additional affidavit as to what follow-up action has been taken pursuant to the issuance of notification by the government of Karnataka on 21/3/24.
My lord.
He also states, while filing the affidavit, the respondents shall also consider the representation filed by the petitioner herein on 28/3/24, wherein in paragraph 7, wherein at page 6, in paragraph 3 of the same, the petitioner has named some of the persons who were acting as directors. And
and loan outstanding, towards the society. Got it, Mr. Chandrasekhar?
Very much, my lords.
You must file it. The same be filed within how much time?
4 weeks, my lords.
4 weeks. List on. You will say everything, whatever he is saying, the notification need to be confirmed by the district judge.
You have to answer what's been
Yes.
pleaded in the response, my lords.
6-8, serial number 12, serial number 12.
I appear for the complainant.
Yes.
I appear for the accused. Since the matter pertains to the child, it may kindly be referred to mediation. We will see whether there is any meeting point.
Then a counsel for the party states that the parties be referred to mediation process under the aegis of the Karnataka Mediation Center.
Yes. A date may kindly be
Yeah.
fixed for the appearance.
The parties through their counsel shall appear before the mediation center on list before the court with the report of the mediation center on give both the dates.
Next Monday, 23rd. 23rd, madam, mediation at 3 p.m.
23rd.
23rd. 5-8, court. Serial number 13, Sri Anil Ramachandra, 13.
None for the petitioner adjourned to.
19-8, 14. Serial number 14, Sri Venkatesha.
Yes.
Please, my lords. Item number 14, 15 and 16, my lords. These are matters pertaining to NPS and OPS, my lords. My lords, the single judge wide order dated
The matters are pending. in writ
25
appeal.
July 23, my lords, had asked the university to consider my representations, my lords, in view of the in view of the observations made in the order, my lords. However, my lords, I give my reply within 2 months, my lords. They don't consider. 1 year thereafter, I file contempt, my lords. Thereafter, they file the writ appeals, my lords.
Wait, writ appeal is pending.
Writ appeals are pending at
serial number 25,
my
my
lord. 24.
24.
Serial number 24. 3 connected writ appeals are there.
So both are connected with this.
They may be connected, my lords. With the contempt, the writ appeals might be connected.
So those contempt arises from the same order which
Same
is
order
under
against
appeal.
which we have filed writ appeal. Please.
Yeah, 24 and
Serial number 24, 24.1 and 24.2.
just say that. Yes. Now who appears for the appellant in 24.1?
I appear for the appellant, my lord.
Okay.
My lords.
We will list contempt and those appeals together.
Please, my lord.
You have asked for whom?
Yes, I am appearing for respondent number 4, the pension fund regulator, my lords. The direction in the honorable court's judgment, there is no direction to us, my lords. Kindly see page 60 of the contempt.
But that will only come your role.
No, but there is no direction to me at all for me to be in contempt. Kindly see page 60, my lords.
Why did you implemented them also?
That's right, but in fact, there is page 60, my lords, having held so.
You are whom?
I am the Pension Fund Regulatory Development Authority, my lords. I am the regulator of the pension fund.
Chairman, Pension Fund
Yes, my
Regulatory
lords.
Development.
I've been unnecessarily dragged in this, my lords, and they are issuing emails threatening me of contempt action, saying that I will be made to come to the court physically, my lords, when I have no role to play. There is no direction mandamus to me by the court.
I'll seek my instructions on this, my lords.
Just say this, just list contempt and both the appeals number so and so on for hearing on. Just give it in August.
That's one more submission.
Mr. Sudhindra Lana counsel appearing for respondent number 4 states that the respondent number 4 has been unnecessarily implemented as a party respondent in the contempt petition as there are no directions in the order of which non-compliance has been alleged against the respondent number 4.
One more submission.
Learner counsel for the petitioner states that he shall take instructions and act appropriately.
Please, lords, there are some unserved respondents in the writ appeals. I may be permitted to take out notice to them through the advocate who have represented them before the learned single judge.
In the meantime, notice shall be served in the writ appeal 1079/24, 1084/24 to the unserved
And
respondent returnable on. Ma'am, all three together, ma'am. 24.1. and 24.2 also, 3. 15 plus 24 and 24.1 and 2. Okay.
13, 8.
14, 15, 16, my lords, 3 matters.
Oh, 14, 15, 16 together?
Yes, my
So we'll all have together 14, 15, 16 and 24, 1 and 2 also. Okay.
Obliged, my lords.
I'm grateful, my lords.
17, number 17.
Yes.
I appear for the complainant in the matter.
Ma'am, 18.
Direction issued by the learned single
Even to
judge.
understand on 6th of July 24.
18 is not connected with the contempt. Oh, sorry. Okay. 14, 15, 16. Yes.
I undertake to enter appearance on behalf of R1, my lords. And on 6th of July 24, there's an endorsement given. I might be permitted to serve a copy. But then,
What have you done?
my lords, we've actually rejected the request and we have reasoned that as the petitioner was no longer alive when the claim for the salary grant was made, the legalists are not entitled to the pension. That's the
Why?
the formative part as such, my lords.
Can that be, Mr.
There
Chandrasekhar?
should be some further justification. I'll
Are they not entitled to the estate of the deceased?
My lords, I'm unable to fully justify the endorsement because there's a reference to the writ appeal order saying that it fully covers the issue in reference. But in actuality, we should have brought the same before to the notice of the learned single judge, which we have failed to do so. So I just requested
On merit?
on merits, my lord. So there's a positive direction issued in favor of the petitioner complainant herein, my lords. I would request for some time for me to get proper instructions in the matter.
Just say that Mr. Chandrasekhar seeks and is allowed. How much time you will file for affidavit?
3 weeks, my lord.
3 weeks to file affidavit. He has handed over to the counsel for the petitioner. Endorsement dated?
26 July 2024, my lord.
23 July 24.
26.
26
July 24.
Whereby the claim of the deceased employee, he has expired, na?
She has expired.
He has expired. Deceased employee has been rejected. By the respondents. Deceased employee, namely Reginald De Souza. Next.
28/7. Serial number 18, Shri Harish. 18.
For complainant.
We'll let her go. Yes.
Harshit, for complainant, there was a positive direction to consider my representation for effecting kata in my name, which is not
Mr.
done.
Chandrasekhar, you are appearing?
Well, it's BBMP. Affidavit is filed, and that affidavit itself would amount to further contempt.
BBMP and the advocate has entered
Just
appearance
say
also.
that there is no appearance for the respondent number 2 and 3. Is it 2 or 3? Who has to comply?
It's a respondent's.
Respondent number 2 and 3. 3? Oh, one.
Ajay and Arun.
Who has to comply?
It's respondent number 3.
Respondent number 3.
Yes, sir.
Full stop. We find there is respondent number. We find there is no appearance for respondent number 3. Full stop. Appropriate shall be the respondent number 3 shall be present in the court on the next date of hearing. Full stop.
7, 8. Serial number 19. 19.
My lords, in this matter, I request for some time. The arguing counsel is not keeping well, my
At
lords.
the request of counsel for the petitioner adjourned to.
7, 8. Till number 20.
Appear for the appellant in this case. The appellate copy was not served on the first part, Your Honor.
Pardon?
Till today, the appeal copy was not served on the first part.
Who has to serve him?
I have to serve copy,
Cannot
but
serve till today.
no, I don't think you have entered caveat.
Yeah, I know, there's contempt, I filed a contempt petition. Contempt was
Yes.
posted.
I will,
It was not listed.
I will serve it during the course of the day, my lord. Then.
Just give him a copy.
Yes, I will give
Let a
him.
copy of the appeal paper book be given to the counsel appearing for the respondents Shivappa.
Shivappa Kudi.
Respondents during the course of the day.
Yes,
List
and
on.
1 second, my lords. He has filed contempt petition 453 of 2024. Lords tweak my lords order to list this appeal along with that. Somehow it is not listed. It may be tagged on to
What is the date we have given in
16.
contempt? Just show us that order, ma'am. Why is it not listed?
4/3 was.
It must be in contempt. That order of listing must be in contempt. Shows? It would not be here. It would be in that.
.453 of 24.
Yes, last week the contempt petition was listed and the order sheet may be in that contempt petition.
First, we have been informed. Hey, is there any date in contempt?
Contempt to today was.
Today?
Today, no, contempt was posted last week,
No, it was on 12th.
12th.
12th it was posted today.
Just show us. We have given pictures. So just say this, list on 16/7/25 and the contempt petition is contempt petition 453 of 24
Yes,
is listed.
please,
Note down the date, 16th of July.
please.
Your last, I am facilitating just during August.
No, just get it mentioned on your behalf on 16, we will adjourn it. Okay?
21.
I appear on behalf of the complainant, my lords.
Lord, I appeal for the accused man. May I request 2 weeks to file my reply in this matter?
My lords, this order is of the year to 1st January 2024, 10th January 2024, my lords. Almost a year and a
What
half.
was the direction?
The direction was to the BBMP to redo the seniority list to the cadre of manager without granting retrospective
Why, what
promotion
happened?
to the.
What are
Lord,
your
my
instructions?
name is not been shown today, my lord. I'm
This-
sorry.
forget this.
I'm sorry, my lords. I have
This
no
is,
instructions.
this is insofar as you as a counsel.
Yes, my lord, I have
We
no
are more
instructions.
concerned on those officers.
Yes, my lord, I have no instructions, my lord. I will seek
Well, who
instructions.
was to give you instructions?
Lord, the,
We'll ask the officer to be here and to give you instructions. We'll ask him.
my lord,
What is this? Rather than they should chase you saying that, look here, these are the instructions. There is a contempt which is pending against them.
no, my lord, they were not, notice is only served, my lord.
Who is the officer? You have to give the name of the officer.
I'll.
No, give now. Ma'am, who is the officer?
My lords, the commissioner has been made a.
Let's see who has to comply. Just show the file.
Lord,
There is a
Not like
specific
this.
direction just to the BBMP.
Tell us who is the officer. You have made only the chief commissioner as a party.
Please.
Who are the other commissioners below him?
Lord, special commissioners, my lord, there are special commissioners and there are assistant commissioners, my lord. May I
We'll
request,
call
my
the
lord?
special commissioner.
No, I'll just seek instruction to whom this matter comes. I'll give it to the court.
Just give it pass over.
Yes.
22, number 22.
Appearing for respondent.
My lords,
Appearing.
contempt petition, my lords, in a miscellaneous first appeal, my lords, there is an order passed not to alienate the scheduled property, my lords. Order was passed on 10th of February. On 9th of January, the contender herein has entered appearance in the matter in the MFA. After hearing all the parties, my lord, a detailed order comes to be passed. Injunction is granted. Thereafter, my lords, what has happened is that the contender has entered into an agreement with various others, but he's forming an apartment block. So therefore, portion of the property as a completed apartment, it is being sold. Now, my lords, in the EC, the information, as soon as we realized, we sent a contempt notice in October 2023, my lords. After sending of the contempt notice and after receipt of notice, there's no reply to it. Thereafter, my lords, I have filed the contempt petition in September 2024. My lords, now a reply is coming to be filed. And in the reply, my lords, there are three contentions raised. The first contention which is raised is that I did not have knowledge of the order. That contention, my lords, is as per the order sheet of the MFA itself, it's wrong. Even otherwise, the notice has been received by him. So that argument would not. Second contention which is raised is that I am not violating the order because, my lords, it's a suit for partition. My brother has conveyed by way of a gift deed a portion of the property to his wife. His wife is also a party to suit, but for impleading application is now filed. But my lords, he's saying that I have sold, he's a party to the suit. DS Max is party to the suit. But he's saying I have sold the share belonging to the wife, and therefore there is no contempt of the order. My lord, that's a very superficial distinction which is being drawn out to say that I may be bound by the order, but I'm not selling the portion to which I am bound. I'm selling someone else's portion. That is the contention.
My lord,
Third
1
contention.
week time granted to comply office objection and one some of it. Week time.
Who is this gentleman?
He's the managing director of DS Max.
Him be in the court next date. We'll hear from him. What is his name?
Mr. Dr. KV Satish. He's the managing director of DS Max.
Which respondent is he?
Arthur.
My lord, he's
The one.
respondent number 24. He accused only sole accused, my lords.
Yes. Just say that. Okay.
My lord, kindly pass over.
Just say this. We have. You have anything to say on the submission made?
Yes, my lord, kindly
What is
pass
that?
over. Pass over. My senior will come here.
Pass over.
Serial number 23.
On the last occasion also, advocate for the complainant was not present.
Sure.
We have filed the memo on 19/3/25. There's a positive direction in favor of the complainant.
Just say that there is no one is present on behalf of the petitioner. Full stop. Mr. Chandrasekhar states that this is possibly because that there is a positive direction in favor of the petitioner complying with the order against which contempt has been filed. That's right?
My lord.
We dismissed in default and non-prosecution.
24 adjourned. Serial number 25, Shri Raghavendra Gayatri.
Serial number 24, they have not informed us, my lords. And this is the 9th time it's coming for PF, my lords. Kindly a date may be given in this.
It was, the contempt matters were tagged along with these appeals.
Where is the contempt?
14, 15 and 16. my lord.
Oh, yes. Ma'am, we'll do one thing.
Please, my lords.
We will have it on, what is the date, ma'am?
13/8.
13th of August.
Please, my lords.
There are 3 contempt which have been filed,
Please, my lords.
and these appeals are also pending. So this is regarding those pension, na?
Please, my lords.
A new pension scheme and the old pension scheme.
Yes, my lords.
So we'll have it on that day.
Please, my lords.
Next.
Much obliged.
25.
Yes,
Please.
we'll have it. This need to be argued, na?
Please, my lords. Pleadings are complete, my lords. We're ready.
See, we'll place it before any other bench. Just say that re-notify on.
In connected matter, there is a delay. Delay may kindly be.
We are not saying anything. We'll just simply re-notify this matter.
Please, my lords.
Just give it in August also.
11/8. 26, P and Harish.
For the accused, my lords.
Lord, I'm for the complaint. There are two issues, my lord. One is according to my client is done by complaint. And so far as the issuance kata is concerned, is not certain. I have asked him to get the certificate copy. Kindly call this on next week, my lord.
We'll
If
give
it-
you a date at the request
Please.
of counsel for the petitioner adjourned to.
5/8.
Please.
Grateful.
27.
My lord, for the appellant in this,
Yeah, but you have to serve R1, R3, R5.
notice dispatch, my lord.
Notice to R1, R3 and R5.
We have done the
Applicable
process, my lord.
Pardon?
We have done the
Yes.
process in April, my lord. My lord, in this matter, there's 168 days delay.
Yes, we will see that. You have any objection, Mr. Chandrasekhar? This not concern you.
My colleague appears.
It's all right. We'll leave it. Just serve these people, ma'am, R1, R3, R5.
My lord.
18/8.
My lord, any shorter date, my lord?
Not possible.
Your Lordship, one small submission in this matter, Your Lordship.
To actually submit on the interim order, that's, your lordship will permit, I'll
28. Ranganath Joyce. 28.
Yes, you want to file reply?
My lord, this case where petitioner is a senior citizen, 64 years, my lord.
What about reply?
And
there's an appeal
the
file, my
director to be
lord.
regularized after long litigation.
What is the direction?
28, there's an appeal file, my lord. Appeal is also set for the
To the
day.
very order of the single judge.
Okay. Acha, just see. Who appears in the appeal for 1 and 2?
Lord, 1 and 2, the contemners.
Mr. Joyce, you appear for 1 and 2?
My lord, the appeal has to be, no admission has to be, notice has not been ordered. My lord.
But
It is
you
a-
have
they have to
the copy
argue
of the
for
appeal?
admission because
You have the copy of the appeal?
I have a copy of the appeal. I have received, my lord,
Just
copy of the appeal.
re-notify, just re-notify.
Short date, my lord, short date. Because he is a senior citizen, driver, my lord, retired, but not pension paid.
11/8. 29.
Petitioner, my.
Yes.
My lord, there is a judgment of this honorable court which says that the name of the public funded building should not be named after living political personalities, my lord. Here, your lordship may kindly say, despite that order, my lord, there are several public funded buildings built by the corporation and the Jilla Panchayat, my lord, have been named after two father and son. They are both are politicians, sitting minister, my lord. Lordship may kindly see the judgment in page number 30, my lord.
Now, what is the maintainability of
My lord, there is a office objection which says already there is a order, therefore writ petition is not maintainable. That is not proper, my lord. Order is the judgment of this honorable court is pertaining to one MLA. MLA had kept his name for one Jilla Panchayat playground, my lord. This order is pertaining to that. But the principles laid down here is applicable to this petition. Therefore, I have to
appear for whom, ma'am?
For the panchayat, please, my lords, respondent number.
And
4.
my lord,
Please.
Who
And-
appears for 5 and
Here
6?
represent.
for respondent 5 and 6.
Both.
an office
We'll
of
hear it, then we'll set up for you.
my lord.
I'll
Office
file my
objection may be
I'll file my
overruled, my lord. Because
It has come up
Lordship
for
may kindly-
maintainability.
all the buildings, my lord, they have kept their name, my lord, though it's public funded. 7, 8, every playground, every road, every park.
Office objections is overruled, not by your lordships. I will file my objections. There are rules, my lord.
You tell us one thing, what is the maintainability issue?
To my mind, my lord, it is maintainable.
It is
Maintainable because
maintainable, huh?
Ha.
That's fair, good, we will say so.
because my lord is in a public interest litigation saying that living person's name shall not be there. There is a writ petition to that effect
Where
judgment.
is that meant, just show us the maintainability objection.
Office says because of that judgment, this writ petition is not maintainable. That judgment is annexure
My lord, page number 35 is the last.
Annexure A.
That should be left to the court to decide. The registry will not decide. Which paragraph?
ಕೇಳ್ತಿದ್ದಾರೆ judgment ಯಾರು?
Judge,
Annexure A, page
Judgment.
34, para 4.
Say it shall not be named after any living person and certainly not in the name of a public figure who is in certain degree. This is his grievance. What is his grievance in the petition?
Grievance in the petition is, there are certain other places where names of living personalities are named for the public places. Therefore, it should be removed. That was his.
That's what is, and what is the observation in this judgment? See paragraph, page 34. At fifth line from the top, sixth, it shall not be named after any living person and certainly not in the name of a public figure. So he is taking support of this judgment.
Correct. Correct.
Just say that learner counsel for the respondent 5 and 6 fairly states that the present petition file with the prayers sought in the petition.
Lord, it's a very simple prayer. Just a writ of mandamus to consider the representation.
I have my objections, my lord. I have got the rules.
On that you have objection.
Yes, yes.
Oh,
Main prayer, I have got objections. I will place the rules.
very well, we'll see that. Okay, and as such, the objection is overruled. Notice issued. Notice has been issued, ma'am?
Yes, sir.
Huh? Then you file your counter affidavit.
My Lord, representations is given to, my Lord, the authorities. If he has any objections,
Why don't you represent that?
he may come before the authority, make his submissions.
If it
But
is to
the
be
prayer
considered,
is-
Lord, what my learned colleague says is, let there be a direction to consider his representation.
No, no, 1 minute. What she says is this.
Ah.
Representation made,
Correct.
while deciding the representation, they should hear you.
So that will suffice.
That would suffice?
Oh, that will suffice. No difficulty.
What do you say?
my lord, court can make some observation with regard to the principles laid down in this
We
judgment.
say nothing. It's for the authority to apply the mind and you will also be given a hearing.
Please, my
He will
please,
also be given a hearing.
please, my lord.
Both of you will make it, let him take.
Please, my lord. Please.
Just say that the present petition has been, now thereafter, the present petition has been filed with the following prayers. It is agreed by the counsel for the petitioner and the respondent number and all the respondents that appropriate shall be that a direction be given to the concerned authority to dispose of the what is the date of representation?
My lord, 25/7/23.
7/2023.
And
Representations.
yes, my lord.
Representations dated 25/7/2023.
And one is 25/7/23, man.
After hearing the, the councils will appear or the parties will appear?
But
Councils will appear. my lord. So
After
from my
hearing
side,
the-
councils will appear.
After hearing the
No,
councils
they
for
are
the,
over 90. my lord.
councils
client
for the
is 95.
parties, counsel for the parties. Full stop. This is agreeable to the council appearing for respondent number 1, 2 and 3. And even 4. Full stop. If that be so, the petition is disposed of, directing the concerned authority to, yes, say competent authority to consider the representations filed by the petitioners by giving a hearing to the counsel for the petitioner as well as respondent number 4 and 5.
Respondent number 5 and 6.
5 and 6, full stop suffice, and dispose of the same within a period of
1 month.
4 weeks after the culmination of the hearing. After the culmination of the hearing, it is made clear that all the contentions of the petitioner and the respondent number 5 and 6 are left open to be canvassed before the competent authority.
Correct.
Disposed of.
Much appreciated.
So number 30, Sri Ravi Kumar.
In this case, we have complied, my lord.
Counsel for the complainant, my lords.
Want to withdraw?
That's respondent number 2. Yes, my lords, it's been complied.
Then a counsel for the petitioner by stating that the respondents have complied with the order seeks to withdraw the petition. The petition is dismissed as withdrawn.
Obliged, my lords.
Complaint subject, place the record.
The compliance affidavit filed by the respondents is taken on record.
Yes, along with
Got a
photo.
copy of it?
Yes.
I've got a copy of it, my lords.
Just filed it today. Yes.
31, serial number 31.
Lord, appearing for the complainant, my lord.
Appear, my lords, for the accused, my lords, we have filed writ appeal against the order, my lords, passed by the learned single judge, my lords, in writ appeal number 281 of 2025.
281
Please, my lords,
of 25.
25.
When is it listed?
Lords, it's not listed before the court yet, my lords.
Then we will adjourn the contempt. You get that thing listed.
Please, my lords.
We have been informed by the counsel for the respondent that the respondent has filed a writ appeal, but the same has not been listed. Re-notify the contempt on
20th August,
Please.
Much obliged.
32. Narendra Gowda.
3/6 they have given endorsement.
Just now they are giving endorsement, my lord, kindly.
Order was passed as belatedly as 3rd of June, my lords. I just passed on the endorsement.
I look into that, my lord, it may be taken up next week.
Because what have you given?
My lords, it is with regard to regularization of unauthorized cultivation, my lords. So it's with respect with regard to the grazing lands of the state. As there is no sufficient grazing land, we have rejected his application for.
This is an endorsement.
It's the endorsement.
Then Mr. Chandrasekhar has handed over the endorsement dated 3rd of June.
Very much, my lord.
2025 to the counsel for the petitioner who seeks some time to look into the same. Just give it.
68, 33, Rajit. 33.
I am for the complainant in this matter.
I am tendering the interest portion by way of DD.
What are you giving?
Demand draft for the interest portion, principal amount.
1 second. Sir.
My submission. I will give it.
So what remains now? Anything more to be complied with?
Yes, my lord. They have filed one more memo of calculation from the date of demand. Your lordship kindly see my objection at page number 12.
What do you say?
Notes there is a direction to the bank to pay notes 38,77,500 with interest at the rate of 6% notes from 30th July 2020. Note they preferred writ appeal before this Honorable Court. This Honorable Court was pleased to modify only to the extent the date from which the interest is payable. I may be permitted to pass on the decision of this Honorable Court.
So how much is payable according to you?
Notes as on today, note they are liable to pay interest from 4/11/2020.
How much that amount comes
Notes
to?
20,58,000 at the rate of 12% per annum.
How much they have given you?
Now they have given 9,22,441.
10 lakh under and TDS has been deducted. 10%.
All right, but
Yes.
still not 20 lakhs.
No, my lord, I will make submission. Kindly see page number. Just you see my lord, writ appeal order portion. Here, just now I pass over. Your lordship kindly see. During pendency of the writ appeal, they filed the present contempt petition, my lord. Thereafter, writ petition has been disposed. My lord, page number 12, my lord, order, para 12. Para 12. At this,
Yes.
at this stage, learned counsel for the appellants would submit even the direction of the grant interest from the date of representation respondent that 37/2020 is erroneous in as much as the first representation made by the respondent to refund the amount was only 4/11/2020 and not 37/2020, and hence any grant interest must be from 4/11/2020 and not from earlier date. It is modified while dismissing my writ appeal, my lord. Then, your lordship kindly, para 14. If that be so, not interfering with the order of learned single judge and upholding the same, the direction at 2, page 33, impugned order of the learned single judge shall henceforth read as follows. The respondent bank shall refund the amount to the petitioner herein within 8 weeks from the date of receipt of the copy of this order, which shall be 6% interest from the date of first representation of the petition, that is on 4/11 till payment. In the view of the learned single judge, having
So
taken
the
view,
interest will start from November 4th.
yes,
So instead of July, it would be November. Okay. Now, from November, it would be 10 lakhs according to you. See, you must file a breakup, na?
no, your lordship, kindly see my memo. Today I filed the memo of calculation, first page.
Yes.
Your lordship signed. The accused bank has filed writ appeal so and so, so and so. Para 2, my lord. Accordingly, accused bank has paid 38,77,500 by way of demand draft so and so drawn in favor of the complaint, a bid amount paid by the complaint with the accused bank. We already paid in the earlier occasion. Then it is submitted now. The accused bank has paid a sum of rupees 10,24,934.75 has paid by DBS Bank DD so and so in favor of the complaint, and 10% 1 lakh and order has been deducted, being interest at 6% from 4/11/2020 to 31/3/2025.
Your calculation.
Lordship, may kindly come to page number 34 of my contempt. Lordship, may kindly see the direction by the learned single judge. Notice, if they pay the amount within 8 weeks, the interest payable is 6%. If they fail to pay the amount within 8 weeks from the date of the order passed by the learned single judge, bank is liable to pay interest at the rate of 12%. This direction is not modified by the order passed by this honorable court. Therefore, my humble and respectful submission, they are liable to pay interest from 4/11/2020 at the rate of 12% till the date of payment. They've handed over the DDA for the principal amount on 1/4/2025. Therefore, they are liable.
There any stay in the appeal?
There was no stay.
Appeal has been disposed of, my lord.
That's right.
No, the single judge of this honorable court passed the order with the effect from 37/2000.
No, that we have read it, but what?
Then only the interest is 6%. Then after 8 weeks, this honorable authority, appellate authority, has modified from the date of 4/11.
My humble submission, if the bank has paid this amount within 8 weeks from the date of the learned single judge's order, my learned friend is right in saying that bank is liable to pay only 6%.
So we are now putting it to you. What we have changed is only the date. Instead of 37, it would be 4/11.
Yes, my lord.
But the rest of the things we have not changed it. You see, come to page 33. The learned single judge says that we have only changed the date from 37 to 4/11. Rest of the directions have not been interfered with. If you have not paid from 37 to 4/11, okay?
Yes, madam.
Initially, within period of 8 weeks, if you pay within 8 weeks, 6%, beyond 8 weeks, 12%.
So
where have we said?
From 4/11.
Yes, where have we said that henceforth the time will start running of 8 weeks and thereafter 12 weeks. So we did not interdict, we did not change any, modified this further orders.
And I will make one submission, my lord. I will not come to, yes, what you are observing is correct. But bank rate of interest, my lord, 12%, not in existence also.
But we have not changed it. You are arguing the appeal again. You are arguing the appeal again.
No, my lord. Once this chapter is closed, I cannot go back.
Then why?
No,
Then why are you saying don't go on 12%? Let's attain finality.
And your lordship, kindly see how they have calculated the interest from 37. Your lordship, kindly see their memo of calculation in the.
Okay. That's the point.
Yes.
We'll ask him to calculate from 4/11.
We'll revise. It's an error, my lords. I admit that there is an error
No,
in the
such
calculation.
case, my lord,
Revise
in such case, I have calculated the 6% as on date. The same amount I will pay without prejudice my rest of submission. Same 6 plus now as I calculate till date 6%.
You have to pay 12% with effect from 4/11.
Yes, my lord. From 4/11 I calculated 6% and paid interest. Now remaining what? How much I have to paid the same amount.
The balance,
Yes,
do it. How much time?
bank official has come and only my submission, he has made branch manager by his name. Because here authorized officer,
Who has to comply? Tell us.
authorized officer.
Who is the authorized officer? See, you are not understanding. How would he know who is authorized? This is something internal issues.
He knows he's participated in the writ petition and writ appeal also. He knows very well. Then why the branch manager put his name on the?
Let's not go into all these aspects.
No, just.
Let's not go into all these aspects.
Allah, however, my brought to the notice of this honorable. He is the authorized, he is present before the court and he has made, and one submission, my lord, I have made the payment in the March itself. So thereafter, I cannot pay the interest for the same amount. They have calculated till date also.
Is it your case? Is it your case?
Yes.
That even with effect from 4/11,
Yes.
you have made the payment within 8 weeks?
No, I have challenged the in appeal. Yes.
So you will calculate the rest?
Yes.
In terms of our order and the learned single judge, pay him.
Yes. In such case, my lord, I paid 6% update and 6% same amount I will be pay within 4 weeks.
We don't know.
No. Let him say. Yes, my lord. And in the meanwhile, let him file the memo of calculation. We will bind it.
Very well. You will pay first.
No, I will.
According to you, even whatever
Yes,
the amount.
I am advised. Yes, according to me, if I pay the same amount, it will be equivalent to the.
He will not say so.
No, I am voluntarily submitting. As per my view, it is a 6% as on date.
See, it's not. You see, you be clear. You say 6% I have given, I will give another 6%.
No, not like that. Let them file the calculation.
Okay.
I will file it. I will pay it. I will pay it.
No, you will pay it. If any deficiency, he will notify you.
Yes.
We say nothing and we will just say that how much time you will take.
No, within 4 weeks I will pay it. One submission, my lord. The interest will be ceased till I refund the amount, not till date.
Obviously.
Yes.
But
No, they have calculated till date also.
The
Principal paid, yes.
What do you say?
Correct, man. They are liable to pay interest from 4/11 till 1/4/2025.
The only issue arises in the contempt petition is whether the petitioner is entitled to 6% of interest at the rate of 6% or 12%. Full stop. So the suffice to state, the order passed by the learned single judge, read with the order passed by this court in the intra-court appeal filed by the bank.
Appeal number 336.
Are very clear. At this stage, learned counsel for the respondent states that the order passed by the learned single judge and this court shall be complied with in 4 weeks.
Within 4 weeks.
In 4 weeks. We'll close the content. Close. Full stop. Noting the said submission, re-notify the contempt petition on. We take on record the compliance of the affidavit filed by the respondent. Just say that.
My lord, his presence may be noted and the branch manager appearance may be distanced.
The appearance of did we call for his appearance?
No.
And there is no direction.
It's all right.
No. Even this honorable court issued show cause notice. In response to that, I have made appearance.
Where is the appearance order?
Someone's notice has come.
Only notice has gone. It's all right. Who is asking his appearance? Unless and until we say don't come.
Yes.
Okay.
Within 4 weeks.
As an exemption.
Yes, my lord.
Next.
Grateful.
Date may be please.
Just give the date, ma'am.
After 4 weeks.
38/7,
Grateful.
serial number 34, 34.
Again for the complaint.
Yes.
Sorry, it's not accused in this matter, my lords. That's what's kindly grant me some time, my lords, to secure
25.
instructions and come back.
Worship, the site is supposed to be allotted in 2005. And they prescribed the fee for allotment of site of 51 lakhs in 2020. That has been striked out by the honorable court and directed to refix the value as on 2010 within 2 weeks. Even after 6 months.
Lords, may kindly grant me about 10 days time, my lords. I'll come back with instructions.
reply be filed within 2 weeks.
Please.
Because he's senior citizen since from 30 years, he's not resigned.
We'll give you a date.
Please.
29/7,
Next.
30, 35, 35.
In this matter, my lord, I am representing the respondent. Let's say
File the reply.
the writ appeal has been filed, my lord, against the order passed, my lord, in single.
What is the date?
Let's say it was listed on 13. There were certain defects. My lord, we are complying it, my lord, within 1 week. It may be taken up.
Date now, what is the date?
Date is not given, my lord, sir. Writ appeal number 191 of 2025.
This will be here only.
Yes.
Just say that re-notify on. Just move a memo for
But
that date.
I'll move it, my lord, I'll move.
Re-notify on, just give a date, ma'am.
Please,
6/8,
please.
seal number 36, Shri Narayan Swamy.
Yes, in this matter, they have filed a complaints report. That is a conditional order, my lords. That says subject to the result of SLP pending. In this case, in this subject, SLP has already filed and that was dismissed.
My lords, this is a different issue, my lords. This with respect to service weightage to be given when there is no clear record for the concerned person having served in the said society, my lords. With respect to that, we preferred an SLP. The compliance after it, in fact, goes on to state that based on the judgment passed in the SLP, the order seems to be complied, my lords. It's subject to, my lords. If I may, my lords, the translated copy of the appointment order, if I may, my lords. One of the conditions, my lords, specify that there is a SLP pending and the appointment is subject to the result of the SLP, my lords. My lords, it's not the same SLP that the counsel for complainant is speaking about. My lords, it's a different SLP with respect to service weightage, which has been explained in the compliance affidavit also, my lords. Why I clearly stated that condition in the appointment order has been enunciated in the compliance affidavit itself, my lords. That is not there.
But what was the direction?
My lords, the direction was to issue appointment order, my lords. And if I may, my lords.
Have you issued an appointment order?
Yes, my lords. Appointment order has been issued, my lords.
What else to be done?
My lords, their grievance is that there's a condition mentioned in the appointment order. If I may, my lords, the revised translation has been.
Weightage of the service.
Weightage of the service, my lords.
So weightage of the service you will give?
I've given an appointment order also, my lords.
No, wait. Says, under this the submission it is directed respondent director consider the case the petitioner for social science teacher by extended. Now, how did he work between this 2007 and till the date of the notification?
My lords, that has been explained in the compliance affidavit, my lords. At para 4.
What remains? What is the weightage means?
My lords, for the service she has rendered, they have to give 5% weightage, my lords. Just I will take my lords to one
They
para.
have to give what?
The service rendered as a teacher, that has to be taken into consideration and give a 5% weightage for each year of service. At the time of recruitment.
For what purpose?
At the time of recruitment. In that recruitment, they have not given that weightage. That's why I approached this on.
Saying that they should relate back to 2007, the appointment.
Yes, my lord.
When did you issue the appointment letter?
My lords, last hearing date.
After filing the contempt, my lords.
After filing of the contempt, my lords, it's been complied. 18-3, my lords.
My lords, just I will read
In
one
fact,
para of the division bench.
Complaint has started working in the organization also, accepting the appointment order also, my lords.
That's true. Why is that conditional order?
The only issue at this point is, my lords, the condition mentioned.
Allah, nothing. Weightage but illa. There is no SLP pending regarding weightage. My case is only weightage that's not given. That's why I approached this honorable court.
Lords, if
I
I
will
may
just
take.
read one para of
Now, he has given an appointment.
that's a conditional order, my lords.
Right, okay, let it be. Now, whether that appointment is after considering the weightage,
Now they have considered the weightage and given the appointment order.
now it has to be confirmed, that's all.
That's true, my lords. Why this conditional order?
Which is that SLP we use?
My lords, SLP. My lords, SLP. It's
Just I will
mentioned-
read one para of the division bench order, my lords.
My lords, SLP
That
number
will make clear.
247.
At page 19, para 5, my lords. Page 19, para 5, my lords, in my contempt petition.
See,
The issue-
weightage is this.
Yes.
Weightage is for each complete year.
Yes.
When they are considering you for a regular appointment.
that's-
Let's hypothetically assume that you give marks while considering for his appointment. Suppose out of, just say 100, he have got 50 marks.
Yes.
You will add on 5%
Yes, my lord.
to those marks
Yes.
and then compute the
Yes,
total.
exactly.
That's the-
Exactly. That's my
But
case.
in any case, what he's saying is, you have actually got the appointment.
No, after filing this contempt, they have given this appointment order that is subject to the result of another SLP pending.
Obviously, when they went, oh, which is the SLP?
My lords,
that's
the
the-
issue,
that's the case.
the issue in the writ petition was, my lords, whether weightage, similar weightage can be given to a teacher who is in fact taught a different subject. That was the issue, my lords.
no,
Subsequently, now the SLP has been filed in the compliance of I've explained as to why I filed an SLP also, my lords. The SLP was filed with respect to when there is no records to show whether a particular candidate has served in that duration.
You filed SLP against this order?
Not,
They have
this
filed
order
in the
came to
last-
be dismissed, my lords. This order came to be dismissed.
So you did not challenge the division bench order?
That came to be challenged, that came to be withdrawn also, my
So
lords.
what remains?
My lords, the issue is, if I may read para 4.
See, let's be very clear.
Yes, my lords.
Unless you challenge this order,
Yes, my lords.
your observation subject to SLP will not bind him.
My lords, it's not the same SLP that we are,
Obviously,
my lords.
inter se parties litigation has attained finality.
Yes.
Yes, my lords.
Inter se parties.
Interstate parties, yes, that.
Some other petition he may be pending consideration,
Yes.
maybe on an identical issue.
Yes,
It will not govern him.
But it's
Unless
not
you
an identical issue. The issue is that it's not a similar issue. If I may read, my lords, I say at para 4 of my compliance affidavit, if I may, I've enunciated why I filed.
Read
Yes.
it.
I state that in
Before
light,
that one subject, my lords,
1 minute. Yes, read
I
it.
state that in light of the above, the complainant is entitled to weightage of 5% for each completed year of service, irrespective of the subject taught. This was the issue in the writ petition, my lords. I state that the service details of the complaint, as per records available with CRIS, are as follows, which is from 2/11/2007 till 31/3/2008, my lords. The complainant has served as a Hindi teacher. 16/6/2008 till 31/7/2008, complainant has been excessively teaching staff. On an excessive basis, she was a teaching staff, my lords. Then subsequently, my lords, no records are available to show that compliance service from 1/8/2008 to 31/10/2008. There are no records to show that she was serving. In view of this, my lords, I preferred a writ petition, SLP, my lords, whether weightage can be given to a person who has not been serving within that duration also. That is the issue in the SLP, my lords.
In that SLP.
In the SLP, my lords.
Then why didn't you challenge this order?
My lords, this order came to be challenged, my lords, on the earlier basis with respect to whether the issue was,
Didn't you challenge this, the litigation initiated by her,
yes, my lords.
the division bench order before the Supreme
It's
Court?
been challenged, my lords, that came to be dismissed also, my lords.
Even in his case?
Yes, my
Yes.
lords, that came to be dismissed.
that is the
And
case.
everything final.
It has reached
It has attained
finality.
finality. So the issue is with,
21, it's annexed.
it's an edge.
In that SLP, you didn't raise this fast.
No, my lords, this issue had never raised.
Filing the-
My lords, that was a different issue that came to be pending, my lords. In fact,
So one SLP has been dismissed, so there ends the matter.
That's why
my lords,
even-
this is a, in this writ petition, my lords, the issue was completely different. Whether weightage can be given to a person who has, there are no records to attribute that person was working.
Then how can you say subject to that SLP?
My lords, the SLP is whether weightage has to be given to a person where there is no records.
This
to-
is something serious.
It has, my lords.
Don't take a ground, that ground.
Yes, my lords.
You went in SLP on a different ground, SLP dismissed, inter se parties becomes final. But there is a third SLP which is pending, on which this issue is there, you say subject to.
Yes, my lords, this is the
What is
conclusion.
this?
My lords, that's the instructions I've received, my lords.
Actually, troubling.
My lords,
This is
in fact,
actually
appointment
troubling.
has been confirmed, my lords, appointment order has been given. She started working also in the said order.
Who is the gentleman who has done this?
My lords, it's the executive director, my lords.
He must be called, he must be hauled
My
up.
lords, I'll seek for a rectification on this
Troubling.
order, my lords. I'll ensure that a
Another
rectification is
thing,
passed in this regard, my
appointment
lords.
order is given in 2025. The recruitment of 2016-15.
My lords, he's
fact
taken charge
remains-
recently, after which he has taken action.
The
my lords.
case, it's a non-issue whether she has worked or not for a period between July to November 28.
No, my lords, it's October.
It's a non-issue now.
No issue, yes.
Now, you can't take against her, and more so when you are given an appointment letter.
My lords, in that, the issue is, in the appointment order, this particular condition has been included. That is the issue of the complaint, my lords, I understand.
So you'll issue a fresh order.
I'll ascertain what.
Fresh appointment order without any preconditions attached.
My lords, I'll
More
seek
specifically
instructions.
this.
My lords, I'll seek instructions on this and file a
What
fresh affidavit.
instructions? We'll call the officer.
No, my lords, I'll file a fresh affidavit also to that effect, my lords.
This.
Because the compliance affidavit reflects that.
Just to fortunately,
Call him.
My lords, it won't be necessary, my lords. I'll give less.
This is overreaching.
My lords, I apologize on behalf of
Actually
the company.
overreaching.
the action is, my lords, they have filed this complaints report and closed the matter. Immediately, just I went out and read the order. That clearly says, immediately I requested the Honorable Chief Justice
Who is the
to
officer calling?
recall.
My lords, it won't be necessary, my lords. I'll ensure it's
Present, my
rectified, my
lords.
lords. I apologize on behalf of.
They are
It was
harassing
clearly
like
stated in the
anything.
compliance affidavit also, my lords.
You will issue a fresh appointment order
My
without
lords.
any conditions, or the officer should be present.
My lords, I'll instruct them to issue a fresh appointment order, my
So
lords.
you get the instructions.
And,
of how to-
I'll instruct them to
The
issue a fresh
complaints
appointment
mu-
order. my lords.
complaints must be from the date of that recruitment order, my lords.
My lords, that.
Pardon?
Recruitment,
No, nothing.
No.
That's not the intent of the order.
that's true.
That's not the.
That's
intent.
that's
Intent
another,
is You will give 5% weightage.
Yes.
At 5% weightage, when you are making the permanent, you will give that benefit of 5%. That means
That's true, my
whatever
lords.
marks he gets, you add on 5%.
That's true, my lords.
Then good.
No, that's true, my
But
lords.
regardless of the
In
subject,
in the
that's it.
2016 recruitment, they have not given that weightage. That's why I am before this, before my lords, my lords.
We have heard the counsel for the parties. We'll stop. The issue which arises for consideration is whether the compliance order passed by the respondents after the dismissal of the SLP, which is the order which you have passed.
My lords, R1, my lords.
In their complaints, page number,
It's not,
19/3/2025.
Dated
18-3, my lords.
18/3/25.
25, my lords.
Is in compliance with the order passed by this court.
Yes.
Para 9 of that order, my
My
lords.
lords, if I may, my lords, the translated version, my lords, there's a small error in that translation, previous
12th
translation.
October 2018 in writ petition 59175 of 2015 as upheld by the division bench on 19th June 2019 in writ appeal number 299 of 2019 has been complied with. So the grievance of the petitioner as urged by her counsel is that the respondents have put a condition that which page is
Para 9, my lords.
My lords, if
Of
I
their
may, in
complaints
the
report.
translated version, my lords, there is a small error in the previous translation, my lords. If I may,
where do you say Supreme Court?
my lords, in fact, if I may provide the translated version, my
Para-
lords, there's a small error in the previous translation.
Page number 4 of their complaints
Page 10
report,
of
my
theirs.
lords.
Para 2,
Para
my lords.
9.1.
Para?
Para 9, my lords. Page number 4 of this complaints report.
We don't have para 9 here.
My lords, the translated version has been.
In-
Para 9 is missing.
No, my lords, in this, the appointment order at
Para
page
9.
10, my lords,
Para
page
9
10,
of their
condition 2, my
complaints
lords,
affidavit, my
the
lords.
order of,
Complaints affidavit. Dated 4/3/2025.
our compliance affidavit ಓದ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. I'm reading the condition from the annexure.
SLP number.
SLP number. ಅಲ್ಲ ಅಲ್ಲ. SLP number ಅಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಾರೆ ಅದು ಬೇರೆ ಇದೆ.
Where is the subject to SLP?
My lords, condition is mentioned, page 10, my lords, condition number 2, my lords.
No, just say this in paragraph, full stop. Condition number?
2, my lords, at page 10 of the translated version, my lords.
Wherein the respondents have stated that
The order of appointment is subject to the final judgment of the.
no, paragraph 4, just say paragraph 4 of the compliance affidavit.
That's in.
Wherein the respondents have stated that wherein in paragraph 9, the following has been stated, page 4, compliance affidavit. Full stop. It is considered position that the SLP civil number, what is their SLP?
Lords, two,
Against this order?
against this order, my lords, annexure
1109 of
1109.
2020, filed by the respondents,
21, page 21, my lords.
has been dismissed
Dismiss.
by the Supreme Court. Full stop. If that be so, inter se parties, comma, the judgment of the division bench of which division bench has attained finality. The judgment of the learned single judge and the division bench has attained finality. Such a condition based on an issue pending in a different SLP could not have been included, would not govern the parties insofar as the compliance is concerned. Full stop. At this stage, and a counsel for the respondent states he shall instruct the respondents to issue a fresh appointment order without any precondition attached to it. Full stop. Noting the said submission, comma, re-notify the contempt petition on.
Well, wait,
Well, much obliged.
37 withdrawn, 38, Jagdish. 38.
I'm appearing for the respondent number 2. I'm appearing for the respondent number 2. Last occasion, we have filed a complaint affidavit.
Milord, in respect of the complaint number 5 and 2, Milord, they are not compliant, Milord.
My lord, may I make my submission, my lord? It is pursuant to the order of the learned single judge to not to relieve the petitioner till the new recruitment is taken place. Based on this recruitment, my lord, in the year we have called the fresh recruitment in the year 2017, my lord. Subsequently, the additional list is announced. In respect of the complainant number 2 is concerned, as per the fresh recruitment, we have appointed.
Where is your compliance affidavit?
Complaints affidavit 18/3/2025, my lord. It's open.
And have you made any regular recruitment?
Yes, my lord.
Milord, that is on 17, Milord. This is after that final order, Milord. They are not made any fresh recommend after.
When was the order passed?
Milord, kindly see the order passed date. Milord,
My lord,
page number
21st
16,
September
21st February
2024, my
2024.
lord. Sorry, my lord, page number 16, the impugned order.
21st February 2024.
21st February 24.
Please, my lord.
Have you made any regular recruitment after this?
My lord, before, my lord, we have called for the notification in the year 2017, my lord. Pursuant to this notification, we have selected, selection list is announced. Subsequently, we have announced the KPSC is announced the additional list on additional list announced on 18/1/2024, my lord.
For how many posts?
My lord, the total, my lord, 239. All the petitioners is guest teachers, my lord.
They're guest teachers.
Please, my lord.
But tell us one thing.
Please, my lord.
So regular recruitment has been taken. Now tell us, after this February 24, did they appoint any regular hands?
No, not there, Milord. That is, Milord, the notification in respect of.
Forget notification. Any regular persons have been appointed after February 24, yes or no?
Yes, appointed.
That's it.
Milord.
The intent is, I will continue this guest teacher till a regular appointment is made.
Yes, Lord.
Regular appointment means maybe based on a notification of 17, but there is a list which is there. They have brought regular people now. Once regular people have come, the guest teachers must give a way to them.
Yes, Lord, but the order is, Milord, after the 2024, Milord, after 2024, they are not called any regular recruitment. Milord, but that notification is, Milord, 2017. Additional list is issued in 2024. Milord, any additional list has to be issued within 6 months.
What did you challenge in the writ petition?
I'm seeking, Milord, the regular appointment seeking.
What was the?
Wait, I'm seeking the, my lord, the writ petition, my lord, because regularization, seeking the regularization.
So, but they have brought the new people now.
My lord, they brought, after that notification, also, they have not,
Doesn't
after
make
the.
any difference.
My lord, that is 2017 notification, my lord. Any notification, any final, any additions, my lord. More or, my lord?
But tell us one thing, how are you operating a 2017 notification?
My lord, this called is in the year 2017 itself, my lord, it's the very same teaching staff.
But there was litigation.
There is the litigation. This, my lord, is after recall the notification, they have come for the filing the writ petition for seeking the regularization. Despite
there
of they
any stay?
applied for the fresh recruitment also.
Was there any stay?
No.
There is no stay, my lord.
But I think the intent is only this. Till they will work, till such time the regular hands come. They say now we have appointed, you agree with that position, they have appointed regular people.
But but the new school is there open, but they have to send there only. New school is there, is vacancies available in the, available, Lordship.
That's not the subject matter.
But, my lord, in respect of the final selection list is issued, after the 2021, after 2021, the final selection list issued. After that, they have to issue the additional within 6 months. They issued additional selection. This is the additional selection. They are selected under the additional selection sheet in the 2024. Or it is itself is selection. Selection itself is illegal, Lordship.
But that's not, we are in contempt.
Because my right is, I am seeking.
You will initiate fresh litigation if you have any grievance.
My lord, fresh litigation, if I'm going to, I'm the only getting the.
You didn't challenge that. You didn't challenge this order. They have brought fresh hands.
My lord, not only me, there are several candidates are there. They disturb me, some of little bit, some of candidates who are the posted, they're having. My lord, they have to disturb, if such thing, they have to disturb whole notification, have this, all candidates have, they have to disturb. They're not disturbing all candidates. Only they are pick and choose, Lordship. That is not permissible. If it is the court has passed the order, order passed, give the weightage, my lord. Sorry, regular till the regular requirements, my lord. They have withdrawn all the appointed candidates, but not done. This is all pick and choose method is not applicable, Lordship. Also, they are not issued any notice, Lordship. If they issue notice, they will challenge that one. They are this one such and such condition. They are the appointed. If any sentence you have to say, they are not issue any in respect of the notice. If that no, if after the noticing, I will challenge the same fresh that after that fresh cause of action or not.
Difficult.
My lord.
You are in contempt.
More or my lord.
Have any grievance? Initiate fresh.
My lord, in respect of fifth respondent, my lord, they are given appointment, but they are allow. But in this fifth respondent, there are one more. I filing here, not my objection, my lord. Kindly, sir. In my place, my lord, they send another candidate, sir, in respect of fifth respondent.
Will you file a response to the compliance affidavit?
Yes, sir, I filed that.
You have filed or not?
I'm filed, my lord, yeah, now.
It shows. What do you say?
My lord, in respect of in respect of 2 and complaint number 2 and complaint number 5, they are not compliant, Lordship. Because of the, in respect of complaint number 5, my lord, they sent in my place, my lord, kindly see, annexure J, page number 3. English version is 4. That is a place, Lordship, they are replaced, my lord. Where there's given.
Are they working today?
No, my lord.
So not.
In respect of fifth response, there is no fresh document, Lordship. This is a oldest document, Lordship. In respect of fifth complainant. In respect of second respondent, in respect of second respondent is the fresh candidate, my lord. In respect of fifth respondent, my lord, complainant, Lordship. He is the earlier his appointment, Lordship.
Why are we going in the, what were the directions to be complied with?
My lord, that direction is, my lord,
you will continue them till such time you make regular appointment.
Yes, this is not a regular appointment in respect of fifth respondent. In respect of fifth respondent, this is not a regular appointment.
What is the appointment?
My lord, kindly see the annexure 4, page number 4. Addition, I filed the now objection, my lord.
Annexure?
Annexure J, my lord, which now I file, my lordship.
What does it say?
They saying the, my lord, they sent the another candidate who was on the deputation, they are issued deputation order, my lord, deputation. In my place, my lord, there's a replace the deputation candidate in respect of fifth complaint.
But have you followed this last come first go principle?
My lord, we have followed. We have followed the principle, my lord.
Last person should go first. How many petitioners are there?
My lord, as per the present complaint is concerned, 5 petitioner. Their complaint is filed.
And
This is a batch of matters, my lord. Batch kindly is a batch of matters. They are not disturb other candidate. Batch of matters, my lord. Batch of candidates, my lord.
juniors to you working,
My lord, they are working, lord.
why do you say so? See, this you should say. The person who joined later than me is continuing, I have been removed.
My lord, that is stated with the petition, accused, my lord. They are not provide that all these details, your worship.
You don't know. You are saying, you say they are working. How do you say so they are working?
Because now that is a political motives, they are taken the fresh candidate, your worship.
You will say so. There are persons who are junior to him, they are working. But you have been removed.
No, now he is the candidate, my lord, who are I given the document, my lord, annexed R kindly see Annexure J. He is the deputation. He is already working another place now.
How do you answer that?
My lord, may I make one submission, my lord? As per the fresh guidelines, my lord, whoever the working in the 4 years in the same some other school, he has to transfer to some other school. As per the new guidelines issued by the KP, the government, based on that, my lord, the is transferred to different school, my lord.
I am ready also. I am ready to work any other school. If they are provided. But then they are not ready.
We are not.
Not like that, please.
We are not replacing the guest teacher to guest teacher, my lord.
Unless you say juniors are working, you have been removed.
My lord.
If you want to say, if you can say so.
Juniors, because that is not a here issue, my lord. The juniors, my lord, they are this is the.
Okay, then we'll close this.
My lord.
We'll close this.
My lord, kindly see, this is Annexure J. In respect of Annexure J, that is not permissible because they are not allow me to work. My lord, if they, in respect of fifth complaint, if they are allow me, I will work, your worship, because that is not permissible.
Do you explain that why he was brought on transfer?
No, this is not transfer.
As per their reply, my lord, now is placed before court, my lord.
Where do you say, why was he brought on transfer?
Regarding that, my lord, we have not filed any counter, my lord. Since today morning I received that.
What was the order was, no one should be, only regular appointment.
Please, my lord.
Then only they will go.
I understand, my lord.
Not on deputation, all those things.
I understand, my lord. Very similar, identical issue, my lord, by this court. We have filed a writ appeal. That is also pending before this court, my lord.
How is writ appeal concerned?
My lord, we are questioning the deputation. The guest teacher cannot be claim the rights to permanent employee place, my lord.
We are not saying, we
Please,
are
my
in
lord.
contempt. You will replace them with regular hands.
Please, my lord.
According to him, regular hands mean regular who have been directly recruited.
Please.
Not a person who is brought on deputation and replacing him.
My lord, we are not replacing the deputation, my lord. Whoever the working in permanent employee in our institution, my lord, we have transferred the teachers to different school, my lord. Not for the deputation, my lord.
How many people you have recruited?
My lord, as per the fresh recruitment, my lord.
239.
Please, my lord.
How many?
Only in subject matter. Only in subject to.
Which is the
Totally,
sub-
my lord,
which is the
6,000.
subject?
Please, my lord.
Which is the subject?
This is the KPSC recruitment, Lordship. They are not recruited.
See, I don't think you should.
My lord,
take
this
it
is social science teachers, my lord. This is
What?
regarding social science teacher.
Difficult. Difficult. He said normal, there is a rule, 4 years, he will be shifted to a new school. So we are not concerned with that.
Not, Milord, this is the earlier, Milord, some same thing, Milord, they are appointed. They are given same other candidates, Milord. In this situation, they are all are in
See,
this,
unless,
Milord,
unless you say junior has been recruited.
Milord, other complainants, Milord, other complaint number 1, number 3, Milord, they are same transfer. They are allow me to work. They are complied. Now in inspector of 5th respond, they are saying that like Lordship. They are allowing me to work, Lordship, in respect of other candidate, other complainants, Lordship.
What do you want? What do you say?
I'm saying that in the same petition, Milord, same complaint petition, other complainant where they transfer the candidates, they return back and once again they taken back me to work, Milord, there.
Who are those? Where do you say so?
Milord, they taken, they given himself in the reply statement, Lordship. In their compliance statement, Lordship.
Which page?
Milord, kindly say complaint, their complaint affidavit, Milord. Annexure, page number 2, Milord. Complaints affidavit.
Yes.
Third A. Shailaj Hanchimani, petition number 1, section, complaints number has been continued to service. In Hindi teachers for the Moraji Destination School, so and so is not. Milord, kindly see the affidavit, Lordship. Where they regular they given me or allow me to work, Lord. In this.
Where it allow you to work, you are working today.
Hi, I am working today now.
All of you are working.
And in respect of the except 2 and 5, except 2 and 5 all are working, Lordship.
All are working.
All are working.
What happened to 2 and 5?
2 because of 2 is Milord, they are regular appointed. Now Milord, in respect of 5, Milord, they are deputed some person, Lordship, in my place.
This person who has come on transfer was in his place.
Please, my lord. 5th respondent is concerned, my lord.
How are the others continuing?
My lord, as per the new press transfer guidelines, maybe they are going to change also, my lord.
Oh, they are going to be.
Please, my lord. And more particularly, my lord, as per the guest teacher is concerned, we have issued a circular. Whoever complete the academic year, they have to file one more. If it is they are interested to continue the post for guest teacher, they have come and give a representation along with the application form. They will take it up. This is the circular we have issued.
Done that.
Lord, that not made circular, Milord. They are not ready to take Lordship. They are not ready to take Lordship because they are the only influential post, Lordship. This is influential post. They are not ready to take.
We have published.
We are the working from since 4 to 6 years, Lordship.
Want to avail that notification or not?
Milord, not issued, Lordship. Then if it is, they kindly provide direct to take, Milord. That is not a notification, Lordship.
He say you can avail that.
No, not Lordship.
Okay, we are not finding any merit in this. Let's be clear.
Milord. So other candidates are working, Milord. Other inspector.
Other candidates are junior to 2 and 5 or not?
Milord, not Milord. They are not. This is a transfer case. Other that similar situation, they are allowed to work.
transfer is also, he is a person who is having a lane, he has been transferred
My
as
lord,
per rules.
that is as per rules. If it is transferred, my lord, they are taken back, their transfer is taken back, my lord, earlier.
You take your call. You want to avail that scheme of guest teacher? You can apply.
My lord, if it is, my lord, I take the information, Your Worship.
Take instruction. At the request of counsel for the petitioner to take instruction, re-notify. Additional charge of assistant tourism because of the financial year end as diffusion or support. Okay, next.
Much of.
Serial number 39. 39.
I was not a party. I filed a review. Review came to be dismissed. Therefore, I am filing the appeal. I have endorsed the office of sections accordingly.
What are you, Acha, this is?
I was a party originally before the deputy commissioner.
You are not party here.
Party in the writ petition, they secured an order in their favor. I filed a review was dismissed.
Issue notice both on the delay application also.
But delays occurred because I was not a party.
I know, you're right, you're right. We will still issue notice.
Office objections may be kindly overruled.
What is that?
That is the office objection as to how I could file a writ appeal.
No, that we will see. Let's law is settled now.
Please.
That's the reason we are issuing notice.
18.8.
Next.
40. Serial number 40. 14%.
Yes.
Not complied, madam. Not complied.
Three-man committee report had to be furnished to the petitioner. Now to the findings of three-man committee, there's an objection filed, but the mandamus was for the state to provide the report as such. The complainant himself acknowledges that we have provided the same.
Shows that, sir.
My lord, report is incomplete.
Just 1 minute, please. Where is the order of which you are seeking compliance?
Page 12, my lords, para 6 of the order, my lords.
Consider below the respondent had to furnish copy of three-man committee with representation in the minute of the report. Did you pass any orders?
28/4/2025, we have furnished the three-man committee report, my lords.
We have done.
We have furnished the copy, my lords.
No, three-man committee report to the petitioner within 1 month from the date of receipt. They shall also consider allegation made by the petitioner in his representation in the light of the report of the three-man committee and pass appropriate orders duly intimate the petitioner.
Now he is aggrieved by the findings of the three-man committee report, my lords.
Very right, very right. He is aggrieved. Whatever is his grievance on three-man, you will look into this. You will look into this representation of 25/10/28 and pass orders. Although there is no direction that he is at liberty to file objections to the three-man committee. Three-man committee has taken a view. He will only look into that. Copy need to be given. You will consider the representation and pass orders.
That's all. Very much, my lord. So if my lordships
Have to
may
pass
further
appropriate order.
modify the orders to this extent, we'll do so, my lord.
There.
My lord, three-man committee report has to be given to him, my lords. He files that he has issues with regard to the inadequacy of the way the committee has been
That's not
reported.
contemplated. In the order,
My
there is
lord.
nothing, he should comment upon the three-man committee. Nothing is there. You see, three-man committee within 1 month, they shall also consider allegations made by the petitioner in his representation dated 25/10 in the light of the report of the three-man committee and pass appropriate orders. Mr. Chandrasekhar, I think then the officer must come. You don't understand, it's just merely giving a three-man committee is not the order, final order. Something more to be done.
More to be done is, my lords, on 12/6/2025. Just now I got the instructions, my lord. So on 12/6/2025, we found that with regard to 4 lecturers, the grant had not to be given, my lords. So we have also initiated action with regard to the same.
So then you will
Even that copy, we have furnished it to
take
the,
a final order, take a final conclusion,
with regard to.
final
what-
decision,
My lords.
convey to him. See, the bottom line is whatever his grievance is there in his appeal, that need to be looked into. That's the bottom line. That you must convey to him.
Not reached its logical end, my lords. 4 weeks, we'll see to that what further steps the government has taken
See,
with
we
regard to
need-
12/6/2025.
What is the date of the order? When was the order?
12th of June 2025, my lords.
Okay. No, not. This order of which compliance is sought.
Compliance, my lords, date of the order of the Honorable High Court would be
24 August. How much time,
24th
tell
August.
us, how much time you will convey this order?
4 weeks, my lords.
As an outer limit, we will not give you any further time.
Very much, my lords.
Just say this, the contempt petition has been filed seeking compliance of the order passed by the learned single judge on 28th August 2024 in writ petition number 18893 of 2021, whereby the learned single judge has allowed the writ petition by stating as under paragraph 6, page 12 and 13. Though Mr. Naveen Chandrasekhar states that the copy of the three-man committee has been furnished to the petitioner, to which the petitioner has also submitted his objections, we are of the view that the order of the learned single judge as reproduced above is very clear, in as much as the respondents were required to pass appropriate orders with intimation to the petitioner. So it is considered by Mr. Chandrasekhar that the final order, as is contemplated in paragraph 6 of the order of which compliance is sought, has not been passed. He states that the final order shall be passed and communicated to the petitioner within 4 weeks as an outer limit.
Very much, my lord.
Stating this submission, re-notify the contempt on.
My lords, may kindly note that in compliance of the final order, certain steps were taken on 12/6/25. But that logical end will come,
Yeah. That's for not us to say.
Very much, my lord.
It's not part of the direction.
As
The
such, my lord.
direction is final order. You will do it.
The
Whatever
second
you're
fold
doing-
order also will comply and communicate as such.
My lord, request, my lord. My appeal petition is, aim is legal action against to the management, DC, district commissioner.
You have said in your representation of
Yes,
18,
yes, my lord.
they will look into it, they will pass. And you must see, the direction is keeping in view the grievance in that 2018.
My lord.
Then you will convey.
In
to
that background, we have to take what's our decision will convey as
Once,
such. my lord.
this is ninth representation, my lord. This is ninth representation. So many representations.
They are concerned with 2018 representation. You may have given subsequent representation. You are concerned with 2018.
My lord.
Yes, next.
28/7. Serial number 41, Shri Atul, 41.
Serial number 44 is the connected writ appeal, my lords.
I have some submissions to make, my lords, in this case.
My lords, serial number 44 in today's list is the connected writ appeal, my lords.
Just take it with 44.
Copy of the writ appeal.
44, there is an office objection, my lord, regarding the photographs, annexure N or the photographs, my lord, there is an office objection. You have produced the photocopy, my lord, that may be dispensed, my lord.
We'll
Unless
have
the
it some
delay-
other day. Your writ
They
appeal.
can
also.
take notice in the connected writ appeal, my
I will
lord.
take notice, my lord, if I may
So
be
there's a
given a
delay, my
copy of
lord.
the
There's
writ.
a delay.
There is a
They
delay
can-
of 169 days in filing the writ appeal.
Just
And
say-
that delay, my lords, cannot be contoned for the reason that after them, they have given, the forest department has issued me a letter in February stating that we will release the 1 crore odd as per the direction of the High Court, subject to you coming and registering the property in the name of the deputy commissioner, in the name of the forest department, which in my respectful submission cannot be done because the 1 crore that was said to be released within a period of 1 month was an interim relief. Thereafter, the entire property had to be revalued, the agricultural land and the converted land. There are a lot of discrepancies here. If my learned friend can pass me over a copy of the writ appeal, I may
serve
only
a
take
copy,
5
my
minutes of the court's time to show certain dates. That's all I want to do. Can you give me a copy of the writ appeal?
We'll serve a copy of the writ appeal, my lord.
Can you
Let him
just hand
file
me
an
one now?
objection if he has for the delay application, my lord.
Very well, but if you can hand me one
Learned-
now,
learned counsel
I just
for the
want to point out
parties.
certain dates, that's all.
Learned counsel for the party states that contempt petition 304 of 2025, item 41. Then
In my respectful submission, my lords, this can be disposed of. The first contempt can be disposed of with the direction for them to release 3.65 crores, which was the first amount that was sanctioned by the government themselves. Now their grievances, it has to be reevaluated because it has to be under the Fair and Compensation Act of 2013, which stipulates a different fora. My only respectful submission is my learned friend can pass me a copy of the writ appeal. I can point out certain
Serve
dates.
a
That's all
copy,
I
my
want to
lord.
do now.
My lord, this is a matter relating to consent purchase, my lord, basically.
It is not consent purchase, it is
under an
voluntary
acquisition.
surrender. That may be misleading the court. It is voluntary surrender.
Surrender leading to consent purchase.
It cannot
my
be
lord.
that
Not-
way.
there's
If
no
today
acquisition
in an
proceedings.
interim order, if I, my lords,
One minute.
my
What is this?
apologies, sorry.
On every plea you are-
My apologies, sorry. I'll let my learned friend finish. My apologies.
You give a copy of the appeal.
I will serve a copy today.
Yeah. We have been informed that the contempt petition 30425 and 138324 arises from an order passed by the learned single judge against which writ appeal 596 of 25 has been filed. In those, 304 say item 41, 1383 say 41.1, writ appeal 596 item 44 bracket. And they request that all the contempt petition and the appeal be heard together.
Yes.
So let a copy of the writ appeal be given to the counsel for the petitioner. Mr. Now, what do you say on this
My lord,
submission?
this office objection, this one office objection, my
No,
lord.
what he says is.
Please.
There is an admitted liability.
No, my lord, in fact, that is the subject matter of the challenge in the writ appeal,
There
my
is
lord.
something which is admitted, which cannot be
We'll
disputed.
definitely look into it, my lord.
Huh?
My lord, that is the subject matter of the challenge in the writ appeal, my lord. There is nothing.
Thus, let's assume worst scenario, even if you succeed in your writ appeal, he would still get that amount of 3 crores.
Not 3 crores, my lord. That is the quantum.
Yes,
That's
I
your
will.
case? That's your
Yes,
case?
yes, that is
No,
my
the
case. If my
direction of
learned
the
can
learned
pass me
single
his
judge-
copy, I will show it.
The direction of the learned single judge is for payment of.
Just
1
give him a
crore.
copy of the appeal.
Can you just show me a copy, sir? 1 minute. I'll just point out.
What he says. He has to come.
My lords may see their writ appeal, my lords, page 10.
What do they say?
They say, my lords, out of the 20 acres that was acquired, 5 acres of it is converted land. Today, they want to challenge by way of this writ appeal to say that that conversion cannot stand. In my respectful submission, that cannot be done. And if it is
Your submission, that cannot be an argument from them.
yes, it cannot. This appeal, my lords, cannot even be maintainable because what they wish to do is challenge the conversion order, basis on which they want to say that that 5 acres of land cannot be treated as converted land, but needs to be treated as agricultural land.
Who has passed the converted order, conversion order?
It was passed in 1994, my lords.
By them only.
Yes, by the government. Their only contention is that I have not used that for the purpose. which is the photographs that,
The land for the purpose for which it was converted.
that cannot be challenged now. Sorry.
Just
my
give,
apologies.
let a copy of the appeal paper book be given to the counsel for the respondent in writ appeal and petitioners in the contempt petition. Petitioner in the contempt petition. During the course of the day, will you give him today?
My lord, 2 volumes are there, my lord.
Within
A
1
day or
week
two, my
from
lord.
today. List the contempt petition and the appeal on, just give a date in July.
23/7.
Before I leave, my lords, may be permitted to make one last submission, my lords. My lords, there is one letter, my lords, that they have sent to me as the counsel. They have sent to me, my lords, in February.
Who has sent?
The Forest Department, my lords.
Okay.
If I may just show that to my lords.
What does it say?
My lords, it says that you are kindly instructed to direct your client to register 15 acres of land in favor of the Karnataka Forest Department for release of 1 crore and as early as possible to comply with the directions of the Honorable High Court and writ petition so and so and so and so. This is what they say. This is as good as admitting to the
This
writ
is
petition
in
order.
relation to the 15 acres of land. This is
But
in
it-
relation to
it's a-
15 acres of
It's a
land.
conditional.
Conditional, my lord, this is a
You were
consent
you were
order.
to do something. And then have you done that?
My lords, there is no onus on me to do this, and I'll explain to my lords why.
Ah.
Today, if I go and register the land, it is as good as me taking consideration for 15 acres of land for one crore,
That's right.
which is against the order of the learned single judge, because the learned single judge has specifically
Very
said.
well. So you are not required to comply with that order.
This is my lords, and this is my lords a backdoor channel for them to secure my land and say that for that consideration, I'm fixing it as 1 crore. Today, if I register it at 1 crore, then the entire purpose of revaluation of that land goes.
But how much the learned single judge has given?
The learned single judge, my lords, had first said, they ought to release 1 odd crore as an interim relief within 1 month from the date of communication of the order. Thereafter, they were to reevaluate the 20 acres as per the Fair and Compensation Act and submit that report within 4 months.
Will that not mean without prejudice, you register it?
No, it will not mean
favor
that.
of the-
It will not mean that. It'll be like this, my lords. In a sale transaction, there is an advance that is paid, and thereafter the final consideration. This 1 crore is as good as an advance. Therefore, I can register a sale agreement, yes, but they want me to register a sale deed, which will, my lords, violate the Transfer of Property Act, whereby a sale deed will fix the consideration.
We will see. Just next.
My lords, the date, my lords. Lords may consider second week of July if possible.
23/7.
23.
A little earlier date, my lords. If
We have to see our board, not follow. You have a difficulty?
No, I don't have a difficulty, my lords. I will file my objections to the writ appeal
Have it
within.
on 23, sir. Next.
Very well.
Serial number 42.
My lord, office objection may be overruled. in
Office
the-
objection. What is that office?
My lord, the production of color photograph, my lord. What was served to us was only a
The
photocopy.
office objection is overruled as it is the submission of, in the writ appeal, as it is the submission of the counsel for the appellant. He has
Actually,
filed the complete writ record.
May
As a
I,
copy of the photographs, my lord, annexure N.
As was
served to us.
furnished to him.
Please.
may I assist the court in this matter? My lords may call for the records in the writ petition also by then, because I have produced, those are my photographs along with my writ petition that I've produced. I'm willing to reproduce them in color if it's required. I can assist the government, I can assist my learned friend that way.
Except the photograph, rest has been filed, na?
Rest has been.
Yeah, rest has been, I'll refurnish it with the memo. I have no difficulty. I'll refurnish the same color. I have the color. for it.
Next.
I'm ready.
42, serial number 42.
Nothing for complaint, Milos. In this case, the learned single judge Milos, I directed
23/5/2025, there's the government order to prefer appeal, my lords. We shall be doing so, my lords.
Mr. Chandrasekhar says that he has instructions to file an appeal of which compliance is sought. Adjourn the contempt petition. Just give it in August, September.
23/8. Serial number 43.
My lords, what happens is in 2024 December, they give a representation to effect kata, tracing the title to a registered sale deed dated 1968, my lords. So we had to write to the defense because substantial lands of the defense adjoins the particular survey number. So when we wrote to the defense department, we have got a reply that the land stands in the name of the defense authorities, my lords. We are corresponding with the defense ministry to give us the notifications to support the said issue.
At the request of Mr. Chandrasekhar to file affidavit.
No, my lords, we have got the reply from the defense. We are seeking additional documents from the defense ministry, my lords.
At the request of Mr. Chandrasekhar, re-notify all.
The representation initially given to them was on 10/6/2024. Even then, it's been 1 year.
2024,
Well, it's then.
2024, tracing the title dating back to 1968, my lords.
1968, it's a registered document.
Let's see that, let's see. Suppose if ultimately it is found to be a defense land, then
Well, yeah.
See, why so much 1968 use?
Then my mother had purchased the property.
After nearly 65 years, they give us the representation, my lords.
For 60 years, why you have?
All the other revenue entries are restricted.
Then let them find out. You have waited for 68 years, no?
Well, it's,
Wait for another.
well, this court's judgment is that, it says if it's a registered document, the prerogative
Correct.
to change the mutate entries.
You kept your registered document in lock and key and sat quiet for 60 years, isn't it?
Well,
And why you have awakened now?
well, I'm a senior citizen. I have the
So is a senior, you waited to be a senior citizen.
Well,
You waited to be a senior citizen to approach the court.
no, well,
Then what?
I came to know.
Wait for some time. Let them file the reply.
11/8. 40.
yes.
But matter pertains to
45.
the directions issued to KPCL to redo the lays, seniority lays as per the,
But who are these people 2 to 18 and 20 to 22?
they are also respondents in the writ petition, and the appellant has no grievance, and many of the respondents have also filed writ appeals. One writ appeal is at serial number 2 in the lays today, and 3 more writ appeals are filed.
We will adjourn because there were connected matters. Which was that, Mr. Bhagwat?
Serial number 2, my lord. Serial number 2.
Serial number 2.
There also, my lord, they are yet to file objection statement filed by the KPCL.
We will have it, Mr. Bhatt. We will have it together.
There are other 2 appeals, my lord. All together, because it's a one order.
Tell us, no. So this is seniority issue.
No, my lord. Kindly, order is concerned, they are not disturbed. Kindly see, my lord. Para, page 90, it is very clear.
Your lordship had an occasion to hear
Serial number 2,
KPTSL appeals.
Serial number 2.
Interim. Now, KPCL we seriously opposed the writ petitions and had taken a stand. Now he is taking a U-turn. He is very much eager to implement the directions. Now, the
KPC.
KPC. It is collecting. It has directed all its officers to submit the details of all the officers. Interim order is passed.
If they implement it, it's fine. Your writ appeal becomes infructuous.
That is the one.
It appears for KPC.
But
my lord has to be.
My lord is yet to issue notice, number 1. Number 2, my lord, kindly take the direction issued by the writ petition. No harm is caused to them.
Right.
Kindly see, my lord, that. Para, internal page, my lord, 53, page 90, running page. Respondent 1 is shall forthwith review promotion granted junior engineers as per its earlier policy memo dated 28/87.
Right, will not cause Mr. Bhagwat. It will just, topsy-turvy, possibly, people may go up, people may come
No,
down.
kindly see that also. Para 1, order of appointment respondent 2 to 22, so and so, elevations are not disturbed. Nothing is,
Which para?
Para 2, para 1. Internal page 53, para 1.
Appointment is only not disturbed.
Yes, my lord.
But the next below seniority and promotions.
6 months time is given to implement it.
6 months.
6 months, my lord.
that is over. Now 4/12/2024 is the order of the single
But
judge.
12
Now,
long
my lord,
years we have
June.
waited. 12 long years. Writ petition is filed in the year 2012. Judgment is rendered in 2024. Blood. 12 long years we have waited in the queue and got some order.
How many appeals are there? You have also filed.
Four
But there are other appeals, Lord Kandi. Yes.
Move a memo. Move a memo.
No, only correcting writ appeals by wanted memo. Otherwise, Lord, I leave it. Nothing else. There are two connecting appeals, but memo is given if your lordship
And there are
permits.
other appeals also according to.
Yes, sir. All four. All four are mentioned.
Who are the councils?
I'm appearing in 618 of.
No, but just check up whether these are your appeals. Just give it to him.
Yes.
All corrected appeals, huh? Very well. But in the KPTCL appeals, my lord, the interim direction is issued.
In which matter?
Uh,
For
today-
that cable. But
today.
what Mr. Bhagwat is saying is this. Those issue, that issue and this issue are not same.
No, there also, my lord, the direction is,
What we have suggested to Mr. Bhatt is this.
please,
Let's assume that issue is same, identical. That is regarding junior engineer, assistant engineer and all those things.
yes.
Whatever is the outcome can bind this
Yes,
also.
very well, very well. Till then, my lord, this is what,
Now they are yet to comply office objection. 90 days. No,
today.
Condition, no,
How many, what are the objections, Mr. Bhatt? You-
And Murad,
when
reply
will you-
statement
when
filed by
will you-
KPCL.
When will you serve them? When will you comply with it? Oh, you are paid. What else?
Statement of objections.
You clear the objections. Just say objections be cleared within 2 weeks. And 45 you want to serve 2 to 18.
But 2 to 80 minutes, they are not necessary. Because they have also filed the appeals. So, my lord, that is, it would be unnecessary.
45 also we re-notify. Just say this, we have been informed by the counsel for the parties that this writ appeal 54825 should be connected with writ appeal 608 of 25, item number 45. As the same arises from the same impugned order.
And there are two other appeals, Lord.
Mr. Bhagwat, who appears for some of the respondents,
One of the, comes in for one of the respondents.
appearing for one of the respondents in item 2,
Item 2 and 45.
in both the appeals, states that there are other 2 appeals. Just show us that, ma'am.
608, 3 or there.
2 other appeals being 608 of 25, no, 611 of 25 and 579 of 25.
Yes, sir.
That's right.
Yes, Lord. Correct.
Be also listed along with these 2 appeals. Learner Council, you appear in which appeal?
608.
611. Learner Council, just say so and so advocate who states that he appears for the appellant in 611 2025. Acknowledges the submission made by Mr. Bhagwat. Who appears in 579?
Mr. Karant.
Sachit Kant.
Sachin Karant. My.
Just say that since now this 579 also arises from the same.
Yes, Lord. Same order.
So in view of the submission made by Mr. Bhagwat that even 579 arises from the same impugned order, we direct tagging of all the 4 appeals and to be listed on, just give a date. In the meantime, counsel for the parties shall remove objections, if any, in these appeals. Okay.
Stay your lordship mein par le. Because now they are in a hurry. But anyway, my lord,
Who appears for this Karnataka Power Corporation?
My lord has to issue notice.
KPC, my lord, sir.
Issue notice in all these appeals. No, issue notice on these appeals, only on these two appeals.
Kiran Kumar Sabrani for
In these
KPC.
appeals to the respondents, returnable on.
But office
Counsel.
objections are
Returnable
yet
on
to
the
come.
date fixed.
The office objections are yet to be complied. Therefore, my lord,
Let them do it, Mr. Bhagwat. Who appears, one, now you appear for whom?
respond number 18. Respond number 18.
Just 18, so and so accept notice. For 18, let notice be issued to the other respondents, returnable on the date fixed. Okay. Thank you.
Sir,
And,
Milord,
and just see the other one.
Not to take, may,
And in the other appeal, this appeal is number 608, which is, you are which respondent?
yes,
18 only.
18.
18. Huh?
There's a delay of 90 days.
Just take down the counsel's name. He accepts notice for 18. Other notice, just.
Sir, Milord, sir.
What is that limited protection?
Milord, this is what they treats, Milord. Sir. May I will pass on. Yes.
Mr. Bhatt, we'll do it. One thing, we'll have it after 2 weeks. We'll have it after 2 weeks. Let the others be there, then we will take a call.
No, may I pass on the interim order?
Mr. Bhagwat, you would not.
Snail face not they are moving.
What is the position insofar as seniority list is concerned?
It is yet to be prepared, my lord. Then even process is not taken. Just they pass a resolution to take a decision. About, my lord, a week back.
See, we want to hear KPC first. We don't know what is the position.
If KPTCL is filed appeal, lord, probably my lord is right. Suppose some order requires. But KPCL is not before your lordship. Your lordship issued notice.
Will you serve them? Will you serve them for after 10 days? Very well, serve them. Then don't say 2 weeks. Additionally, liberty is granted to serve the copy of the appeal paper book to the standing counsel for the KPC. Okay, just give it first week, July. Just 1st or 2nd July.
27.
When will you serve them? Tell us. Just say 26, 27.
4/7, my lord. 2/7.
It's a huge process, really well. Give it on
2/7, lord. Yes, lord.
2nd July. It's a huge process, Mr. Butt, redrafting a seniority. Have they issued any draft seniority list?
Now they have
No,
called
my
for,
Draft, is it draft?
No, no. Just a decision is taken to implement it, my lord. About 15 days or max, my lord.
And how many officers are there?
Lord, large number of officers. More than 1,200. But they will not.
You're not understanding. Everything would be, topsy-turvy, or the churning would take place.
But they will not.
From here, go there, going, coming here.
One submission, my lord. They will not allow to implement the decision because they are occupying director post.
2nd July. Next.
46, Shri Nitin Prasad. Serial number.
There are 3 objections which my learned friend says she will comply with within 1 week or 10 days.
Yes, sir. Awaiting service.
For respondent
Yes.
number 9, my learned friend is filed Bakalat or is filed. You have to file. For respondent number 9.
Just show me.
Delivery the interim order.
Yes, what
My
they
lord,
say.
my lord, the learned judge, my lord, has quashed the order appointing an investigation officer and the forensic auditor. My lord, some of the
Lords, before my learned friend commences, notice is issued and an interim order is passed. It has to be heard. So copies were served yesterday, I'm told, on us, on the R3,
no, copies have already been served
yesterday,
yesterday.
yesterday. Already served, but yesterday. So it has to be heard, my lords, that's the only thing.
All right, if you want life, that is okay.
No, no.
Objection certificate.
No, what is the interim order, Mr. Phanindra?
That the records, if they have, my lord.
Should not destroy it.
That's the only thing which they can. That's operating now.
So we will set out for hearing this.
Very well.
Just say that, all are represented.
Lordship, I undertake to file wakalat for respondent 5 to 8, as well as
One who appears
I appear for respondent.
for one. Two registrar companies.
Notice was issued on the last date.
Wait.
Yes, the notice to respondent number. Now 3, 4, 5, 6, 7, 8.
5, 6, 7, 8.
There are 3 also is.
So let's go one by one. Then who appears for 3 and 4?
3, my lords, we appear. 4, there's,
Who appear, just give your appearance.
it will be given here.
3, 4, so and so 5 who appears?
5, 6, 7, 8.
5, 6, 7, 8 you appear. Okay. And what about 9, 10?
I appear for Miss Laksha Kalapa. I think that also is written in the.
9, 10?
Only 9, only 9.
Who appears in 10, 11,
10
12?
to 18, Mr. Vivekolla.
Pardon?
10 to 18, Mr. Vivekolla has
10
undertaken.
to 18.
8 to 18.
Please.
So that takes care of everyone. Okay.
2 notice still has to.
Well, except 2.
ROC.
Just say that respondent number 2 is still unserved. Let fresh notice be issued through all modes, including hand summons, on service on respondent number 2, returnable on. So it is agreed by the counsel for the parties that is the complete record here, which was there part of the learner single judge.
My lords, it will be a part of the writ appeal. Normally, my lords, in our courts, whatever is filed before the learned single judge should be part of the writ appeal.
Then written submissions along with the judgment they intend to. Just give it whatever is convenient, ma'am. See, April, August.
12/8.
12th of August.
Please.
There is no need to continue this order not to destroy.
Yeah, I think it's still until further orders. I think it's not
There is no
limited.
need to continue it because the order is
It's already there.
It's not time specific, my lord.
Yeah, that's right. We'll come back after lunch.
Court officer, madam. Court officer.
ನಾಲ್ಕು ಗಂಟೆಗೆ ಎದ್ದು ಬಿಡೋಣ ಅಲ್ವಾ ಸಾಕು. ಕಾಫಿ ಗಿಫಿ ಕುಡಿ. ಈ ತರ
Yes. Which is this matter now? Call that matter, we'll just search on it.
230 matter, Shri Subramanya Bhatt.
I represent the petitioners council, my lord. Matter pertaining to the validity of the act, understanding was to hear and dispose of the matter. Pleadings have been completed.
We'll have it some other day.
I understand, my lords, but only a shorter date at 2:30 would be the convenient so that I can persuade the court.
How long you would take?
My lords, at least 2 hours for the petitioner's side. It has got a checkered history.
Is it?
It has got a checkered history wherein this court has passed an order twice, which was confirmed by the Supreme Court. In order to nullify the effect of the judgment, an act came to be passed by the government, and the validity of that act is under challenge.
We'll have it. Just say this. Would August would be better?
Earliest will be the better. No, I am in the.
For December, August is earliest. But it depends, how you look at it.
Let me try in month of
July. We will just see. Just show us the list. Yes, we'll accommodate you. We will have it on 22nd of July at 2:30 p.m.
Please,
thank you. Just say re-notify on 22nd July at 2:30 p.m.
Forty-seven.
Why don't you file a fresh petition? You're right, but then the grounds would come. Same grounds. What do you say, ma'am?
I don't have a copy of the application.
But you should not have any serious objection on this.
No. It's only after I filed the statement of objections did they decide to file this amendment application.
Just give her a copy. Just give her a copy. She should have at least a copy.
My lord, I'll look into it and make my submission.
Just say that learner counsel for the petitioner persists IA 21 of 24, which is an application seeking amendment of the writ petition. He has served a copy of the same on the learner counsel for the respondent who seeks some time to look into the same. At her request, adjourned to. You are seeking amendment in 2133 only. Which are those? Then 2224.
Yes.
You give a copy of that also. Just say that he presses the application for amendment in WP 213324 and WP 2224 of 24. He has given the copies of the applications to the learner counsel for the
Lord,
response.
I've got only one. You'll have to give me. Yeah.
You have both?
No, I have only one.
Acha, he has given the copy of the application in 2133.
My office copy, Millet. I will make it.
For our purpose, we will record what you have done. 2133 of 24. he states that he shall give a copy of the application in WP 2224 of 24 during the course of the day.
Just in half an hour.
You've given me this.
To look into the same, re-notify. Next, ma'am.
13-8,
Obliging.
48, serial number 48.
Appellant, my lords.
This has to be argued.
My lords, it's a simple issue, my lords. It's coming out of a petition, ex parte order that's been passed by the learned trial judge, my lords.
Show us the file.
My lords, if I may take out. The issue is very simple.
What is?
My lords, the ex parte, there is a delay, my lords, of 12 days. I'll explain that also, my lords. But however, I'll come to the merits of the matter for 2 minutes.
Come to the substance. Where is the order?
My lords, Annexure G, my lords, page 153, my lords.
153.
153.
153.
There's an ex parte order that's been passed, my lords, as against me.
Now
There
tell
are
us
3
one thing.
applications, my lords.
Who are you?
I'm for the respondent in the,
So transferring, dealing, restraining account of the petitioner to an extent of 26 lakhs.
26 lakhs. And
Okay.
all the 3 applications have been allowed, my lords.
Date
If I,
of hearing, just 1 minute.
Yes.
Are directed to deposit 20 before the court or to furnish a bank guarantee. What has he done?
my lords, in fact, I'm the appellant in this. Over there, he has got that relief, my lords. The,
He got, otherwise he will deposit in the court.
my lords, that is me. That is, I'm appearing for the respondent, my lords,
Oh.
in the trial court.
Oh. You are the respondent there.
Respondent before the trial court, my lords. In
What
fact, I'm
is-
agreed
what
by
is your-
this
what is
order.
your Name,
Pardon, my lords.
Mutter Media.
Matter media, yes, my lords.
Mutter. No.
Your lordships, there are 2 respondents in the section 9 petition.
One matter media and the other partner, my lords.
Goenka.
They have filed this appeal against this.
Goenka. Goenka is respondent.
I am the respondent,
Acha, you
sole
are
respondent.
the Pugalia.
No, I
I'm
am
appearing for
Divyam.
Pugalia. I'm appearing for Chirag.
Yes, yes, yes.
We got it.
Yes, my
You are Pugalia.
yes, my lords.
So this direction
My lords.
are hereby restrained from transferring this. Further respondents are directed to deposit this or a bank guarantee.
Yes, my lords. If I may take this honorable court through the relief sought in the main petition, my lords. At page 129, my lords, the relief in fact sought, my lords. In fact, the order itself says the relief sought in the main prayer is similar to the applications filed, my lords. 3 applications have been filed. But the main prayer also, in fact, goes on to
What
say,
is the suit for?
my lords, it's section 9 petition, my lords.
Section
It's
9.
Section 9 petition.
It's all right.
My
Doesn't
lords,
make any difference.
my lords, the issue is, I've been restrained. There's a dual restraint imposed upon me, my lords. One is to not to,
No. Will you give a bank guarantee?
my lords, I'll ensure that 26 lakhs is kept in the account, my lords.
Very good. Why don't wave your hand? You will keep it.
My lords,
You'll file an undertaking before the court.
my lords, in fact,
Till such time the arbitration proceeding gets
but
culminated.
in fact, if I may, my lords, it's been more than 90 days since they've initiated this. In fact, they've not even initiated arbitration.
They have.
They have not even initiated arbitration. They are sitting tight on this order, my lords.
Have you filed section 11?
No,
Yeah,
my
Have
lords.
you invoked
we-
arbitration?
We haven't, your lordship, let me also, let him complete his arguments. I have certain set of facts which are very important to highlight here.
My lords, it's
Which-
only with respect to law and.
No, we
the order
haven't
that's been passed have
initiated.
been
We are
addressed before.
wanting to. On the 19th, the arguments are for the
You are ready
final.
for arbitration?
Your
My
lordship.
lords, it might be referred to arbitration
You are
before
ready
this
for
one.
arbitration?
Yes, we are ready for arbitration, your lordship, but
Arbitrator
your
can be
lordship,
appointed before this
the
honorable court itself, my
problem
lords.
is that, the problem is that the 26 lakhs is very important to be protected, and your lordship, they have given an undertaking that they are okay with that. They, please see Annexure M, your lordship, they have given an undertaking that they will
What
deposit.
he's saying, so, 1 minute, undertaking to ensure the 26 lakhs is secured.
Your lordship, we understand that.
Answer that.
Yes, yes.
He says he will ensure 26 lakhs amount is lying, continues to lie in the account. He will file an undertaking before this court, okay? And that will continue till such time the arbitration proceedings are over.
My lords, if I may, my lords, at this juncture, my lords, this honorable court is equipped to pass an order to appoint arbitrator, my lords. I'm willing to subject myself to arbitration.
you
Unnecessarily,
say
an
yes,
interim order is acting against
We
me.
will refer it to the arbitration.
That can be done by this honorable court.
Your
my lords.
lordship, but the only thing is that the bank guarantee needs to be submitted,
That
your
is not
lordship. I will
necessary.
tell you.
I'm willing to subject myself to the arbitration.
Your lordship, the whole issue is that the whole conduct of the respondent is very questionable altogether since the signing of the MOU. Your lordship, I may go into the facts of the case, but as it is an appeal.
We are not required. This is not for this court to look into it.
Yeah, exactly, your
Ask
lordship.
that You are concerned with 20 lakhs, 26
26
lakhs.
lakhs,
to be
your
protected.
lordship.
How does it matter? It is through bank guarantee or it is lying in the account with an undertaking? How does it matter?
I understand your lordship, but this 26 lakhs, their whole conduct has been so questionable. We are just suggesting a bank guarantee, a simple bank guarantee. If they can restrain, they can submit that 26 lakhs, your lordship. I will tell your lordship, a bit of history needs to be understood because of this. There was an exit process which was taken place by me. I am the ex-designated partner. Everything was discussed with the other partner. Everything was done. A balance sheet was prepared. No, the balance sheet has not been challenged by them till date before the pleadings had been filed. Further, the whole conduct, when there were two parts in which this whole payment had to be done. One was 20 lakhs before a certain date and 5 lakhs after a certain date, which is 28/2/2025. What happened is that first they did not pay me the first payout amount which was supposed to be given. When that was not given, we sent a legal notice that what exactly is the issue.
You deposit 26 lakhs here in this court.
My lords, if I may, my lords, I'm willing to subject myself to arbitration. I'll be put in a dire circumstance because I'm running the affairs of the partnership firm at this point. And in fact, my lords, if he's willing to go on merits, I can say that he is not complied with the obligations in the MOU. He is not signed the authorization letters.
1 minute, please. That's on the merits.
Yes, my lords. I don't want to.
You will deposit 26 lakhs in the court.
My lords, I'll file an undertaking, my lords, to the effect that I'll keep that 26 lakhs. My lords, because it's a Section 9 petition, my lords, I'm willing to subject myself to arbitration. I have a severe counterclaim.
What is the difference between, keeping 26 lakhs in your account and depositing
my lords,
here?
I'm willing to subject myself to arbitration, my lords.
Yes.
If an arbitrator is appointed, my lords, I'm willing to go before the arbitrator and adjudicate the dispute before the.
Deposit 26 lakhs here. We will put it in an FD, whatever interest and you're to the benefits of both the parties.
My lords, can I take instructions on this regard?
Don't understand this attitude.
My lords, in fact, my lords, if I go on merits, my lords, I have a very good case.
Forget merit. We are not going.
I understand. That's why the only issue was with
1 minute. We want to know what is the basic difference 26 lakhs lying in your account and 26 lakhs in an FD. Tell us in this court. What is the difference?
Well, in fact, there is no dispute. I'll just confer with the client with respect to how.
It's except the fact that having the satisfaction.
Well, I understand. They want the satisfaction having to look at it, my lords. If I may, my lords.
Okay, we dispose of.
Your lordship, with the direction to
my lords, arbitrator might be appointed, my lords.
You want to be referred to the arbitrator?
Yes, your lordship, just to confirm whether they have been directed to deposit, right?
We are passing an order. We don't want anyone's consent on this. We'll say deposit 26 lakhs. We'll refer we'll take your consent.
Yes, indeed.
Refer it to the arbitration.
Indeed, your lordship. I'm completely fine.
Just say this, the challenge in this appeal is to an order dated 5/3/2025 passed by the trial court, whereby the trial court has on an application filed under Section 9 of the Arbitration and Conciliation Act stated as under. Just see page 157 and 158, both. Okay. The submission of learner counsel for the appellant is that the tribunal, trial court could not have passed this order, as they said the order shall amount to allowing the final relief as prayed for by the appellant, by the respondent. Both the respondent or one?
I represent both the respondent.
By the respondents. Full stop. Though he states that the appellant herein shall secure the amount of 26 lakhs by keeping it in his account, and which in his account throughout till such time the arbitration proceedings, till such time the disputes, interstate dispute between the parties is decided by the learned arbitrator. Though such a submission is, the said submission is opposed by the learner counsel for the respondents by stating appropriate shall be that a bank guarantee should be furnished by the appellant in favor of the respondents herein, so that the amount is secured. Full stop. Full stop. Having noted the submission made by the counsel for the party, we deem it appropriate to direct the appellant to deposit an amount of rupees 26 lakhs with the Registrar General of this court within a period of
60 days, my lords.
Within a period of 2 months, 8 weeks. 8 weeks from today, with the Registrar General of this court. Full stop. On such deposit, the amount shall be invested in an interest-bearing FDR of a nationalized bank till the culmination of the arbitration proceedings in terms of arbitration proceedings through by an arbitrator who shall be appointed in terms of this order. Full stop. It is made full stop. At this stage, learned counsel for the appellant have also given their parties have also given their consent for appointment of an arbitrator for appointment of an arbitrator to adjudicate the disputes between the parties under the aegis of Bangalore Arbitration Center.
Yes, my lord.
Bangalore Arbitration Center. If that be so, comma, we refer the parties to the director, Bangalore Arbitration Center, who shall appoint an arbitrator from its panel.
If this honorable court is
You
inclined,
have any common name, tell us, we'll appoint.
court, it's left to the discretion of this honorable court, my lords. Court can appoint.
You tell us.
Court can appoint, my lords, on
If you
11th.
want, we can have a discussion. Let the court appoint.
Court appoint, my lords.
The court may also appoint your lordship.
Because the discussion is going to take additional time, my lords. Court might as well appoint, my lords.
We just cut the last sentence, Bangalore Arbitration Center. We appoint Justice Rajendra Badamikar, a former judge of this court, as the sole arbitrator who shall adjudicate the dispute between the parties. Will it be an ad hoc or under the aegis of the Bangalore Arbitration?
Bangalore Arbitration Center.
Bangalore.
Rules, center rules, my lords.
He shall hold the proceedings under the aegis of the Bangalore Arbitration Center. His appointment, including the fee, shall be regulated under the rules of the Bangalore Arbitration Center. Full stop. It is made clear that the deposit of rupees 26 lakhs with the Registrar General of this court shall be subject to the outcome of the adjudication of the dispute, interstate dispute between the parties by the learned arbitrator as appointed by us. Okay? The learned counsel for the party states that in view of this order, comma, then that petition also becomes infructuous.
Section 9 becomes
Section becomes infructuous, my lords.
The appeal as well as the Com AA 119 of 2025
Yes.
are disposed of.
Such deposit would have no bearing on the.
Are disposed of. Such suffice to state that the learned arbitrator shall decide the dispute between the party without being influenced by the order of deposit passed by this court in these proceedings. Okay.
Much obliged. Your lordship, just to clarify, the deposit order has been made, but now the parties have to just adjudicate on the arbitration on the final disputes.
See, ultimately, whosoever succeed will get that.
Yes, indeed, your
In fact,
lordship.
it's
It is
our
just to
money, my lords.
clarify.
In fact, it's our money itself, so.
You say you, I say that's.
Fair enough, my lords. It's an arbitrable dispute to begin with, my lords.
That's all.
Yes.
Anything else?
No.
Fine, thank you.
That would have no bearing on the appellant filing any counterclaim, my lords, if at all. My lords. Appellant is.
Very well. Shall adjudicate the disputes between the parties through claims and counterclaims.
Counterclaims, my lords.
If any.
If any. Okay.
All the contentions of the parties are left open, both on facts and in law.
Law.
Be
Obliged.
canvassed before the learned arbitrator.
Much obliged.
Much obliged.
Thank
Much
you.
obliged.
49.
It has to be argued.
Appeal by my lord, the landowner, my lord, notice is
It's a fresh matter. No?
fresh matter. 49 and 50, my lord, same parties.
There is another matter, I suppose. Who appear for the respondents? Oh, there. 34 allowed.
But
34 allowed.
yes, you are allowed. So the landowner, Lord, Lord, it was enhanced. The national,
What do you say, enhanced?
Lord, the landowner, my lord, preferred, my lord,
Before arbitrator.
arbitrator. It was enhanced from the SLO. It was enhanced. Lord, the National Highway Authority, my lord, prefer the arbitration petition before the district court. My lord, set aside the, my lord, the enhancement order.
In both the matters.
In both the matters.
Issue notice.
Call for enforcement.
Anyone for the state government, arbitrator?
Respondent number 2.
So and so accept notice for 2, let notice be issued to 1 and 3.
Please.
18-8, 51 urgent, 52, serial number 52.
52 is a green bench matter, my lord. The pleadings are complete.
Just list for hearing, we'll hear it, not today.
13-8, 53 urgent, 54,
Yes, ma'am.
Appearing for the complainant, my lord. My lord, a writ petition was filed, my lord, and the writ petition was allowed also, and the respondent police was directed to undertake investigation and submit a report within 3 months. They have not done the same, my lord, and the complainant has visited the police station on numerous accounts, and they have not
Yes,
submitted.
for the respondent. Mr. Chandrasekhar, you appear? This 54.
54.
54, my lords.
Yes.
Investigation had to be completed, my lords. The IO is present before this court.
But how long it takes?
My lords, there were some changes in the sense he is present before this honorable court.
Lord, it's been
He
more
seeks
than-
finally 4 weeks' time to complete the
It's
investigation.
been more than a year, my lord.
Let's see that 4 weeks, but we are putting it as an
My lord, so because of the seriousness, the IO himself is present before this honorable court. 4 weeks' time, he'll complete the investigation.
Mr. Chandrasekhar, on instruction from what is his name, just give the details, huh?
My lord, Raju, yes, I'll give the details as such.
Give the details, the IO seeks and is allowed 4 weeks as a last opportunity to complete the investigation. To complete the investigation,
My lords.
to complete the investigation. That's the direction.
Investigation in
3
crime
months,
number
my lord.
23 of 2023, that's the direction, my lords.
The court had directed them to complete.
As was directed in the order dated 31st May 2023 in writ petition 10870 of 2023. Noting the said submission, re-notify the contempt petition on.
48,
Much of that.
55,
So the
What
copy
is
of
this?
the endorsement has been issued, or else they have served it. I may be reserved liberty to challenge the endorsement.
Just a Mr. B. Ramesh, learner counsel for the petitioners, states as an endorsement has been issued which has to be challenged, comma, he shall withdraw the contempt petition. Dismissed as withdrawn.
Gotcha.
56, 57 urgent, 58,
I appeal for the appellant, my lord. Matter pertains to demographic tax.
We'll have it some other day, ma'am. Re-notify on.
Execution is pending. Kindly stay with that.
Execution is pending.
Yes, sir. Execution.
Execution or contempt?
Execution is pending before the trial court.
Is someone appearing? Anyone appearing?
Yes, my lord, yes.
Who appears for the respondent?
Ramaya.
Ma'am, just show us that, ma'am.
Government is not a part.
There was a delay, my lord. Delay was controlled. It was heard in length, my lord, and I had given the decision.
No, this is an order passed by the learned single judge. No?
Yes, my lord, yes.
But why an execution?
Execution because the trial judge had ordered for
12, 13.
When is the date? Execution.
it is pending from 2023.
It's all right, but have they taken any action? Yes, let's see, re-notify.
That's all.
Call the next one.
15, 9, 12.
What has to be done?
12,
But
59,
there is
Need
one,
to be argued.
just a short point, my lord. There's a,
Have it some other day.
yes,
Just say re-notify.
13, 8, 60, (16) 18, 8, 61,
63.
My lord, for the appellant, this.
My lords, for the respondent number one, my lords.
In
This has to
filing.
be argued.
My lord, I want to submit on stay, my lord, to
What stay
stay
of
the,
what?
of the impugned order in the writ petition.
What happened? Just tell us the facts.
Yes, my lord. Respondent number one,
What
I'm
is
the appellant.
penalty? What is the penalty?
My lord, it's for recovery of 13 lakhs 8,000 from the respondent number one for causing storage losses of MSP maize due to misappropriation by him,
But
my lord.
Single judge has set aside.
My lord?
Single judge has set aside.
Yes, my lord, but in that it was not a reasoned order.
Ma'am, we have to hear the,
Yes, very well.
without the appeal being heard, we can't say so.
Right, ma'am. The reason I'm submitting is that the respondent number one has given us a representation because of the writ petition, the single judge order.
See, one thing, let's be clear on this. You are appearing.
I am the second respondent, Union of India, my lord, almost a
Okay, who
quarter.
appears for one?
My lords, I'm for respondent number one, my lords.
See, he should not seek insistence
Yes, ma'am.
for you know, the petitioner appellant to comply with the order.
Please, my lords.
What happened to
lords,
the other petitions?
There are two others. One was at serial number 27 today, my lord. That has gone to 18-8 because the respondent one didn't appear in that matter.
Okay.
And the third petition has not been listed. Actually, it may all be taken up together.
We'll have it on 18th of August.
Yes.
Please, my lords.
And you will not seek the implementation of these orders.
My lords, please.
See, it's
My
not
lords,
like that appeal we will post it for hearing, but at the same time, you are insisting upon implementation of the order.
Please.
Then we will record your submission till the next date. You will not file any execution or contempt petition.
Contempt, yes.
My lords, my senior is appearing in this matter. He is unwell, my lords.
We'll hear it on the next date, but you should not, you know, insist upon implementing the order.
I will instruct, my lords.
Just say that re-notify on 18th of August. Where is the third appeal?
My lord, that has not been listed. I'll move a memo, my lord.
It
For
is,
18-8.
shall we record your submission?
Please, my lords.
Learner counsel for the respondent number one states that till the next date of hearing, he shall not seek execution of the order passed by the learner single judge in dated 23rd April 24 in writ petition number 31402 of 2017 till the next date of hearing. That's right?
Please, my lords.
Okay.
It may be taken up along with serial number 27, my lord. It's arising out of the same impugned order.
Yeah, right. We are having on the same day.
Very well.
You appear for whom?
For the second respondent, Union of India, my lord.
And what about third?
Lord, I
Food
will appear for
Corporation?
respondent number 4, my lord.
Who appears for food?
I will appear for respondent number 4.
What about FCI?
FCI notice I may have to go.
Why did you make FCI twice?
My lord, they were parties in the writ petition, exact same cost title we have to.
One is the managing director, two is the general manager.
Yes, my lord.
Are they necessary party? How are they connected with the issue?
Because it was their goods that was stored.
It was their
MSP,
stuff. It was
MSP.
their stuff.
Yes, that's why, my lord. They may have to be represented.
Issue notice to 3 and 5.
We have served actually, my lord.
And they have been served?
Yes, my lord.
Okay, don't say that.
Yes.
Just re-notify 18th August.
Obliged.
Obliged.
64.
64, my lord, there's a connected state appeal, my lord.
What about the reply?
No, my lord, there's an appeal that has been filed, my lord, challenging the impugned order.
When is the appeal?
Listed today, my lord, it is connected along with the contempt. See, 4.1 is the appeal of the state government.
What is the issue?
Lord, I was not appointed on compassionate basis. Not appointment was approved. What they did, not that is after I approached this honorable court, not obtained a direction, and not afterwards it was done. But they approved the appointment from a later date. The learned single judge, my lords, on challenge, Annexure X order, my lords, said it has to be from the date I was appointed in the institution. I should be paid by fixing the salary in this case. Annexure X, my lords, it starts at page number 120, my lords.
Which page?
120. 122, my lords, para 5 and 6, my lords.
Into contempt. Referring to case number to contempt.
From which date he should be? What is salary grant?
My lords,
That is
the
the-
institution, my lords, is extended with grants by the government. My lord, that is in respect of the salary, my lords, which is payable to the
So
employees.
on which post the son was appointed?
My lords, the petitioner, my lords, is the son who was appointed in his
Which post?
lords, Group D, my lords. Group
And
D.
what was father working as?
My lords, he-
Watchman.
Watchman, my lords, another Group D only.
Group D only. So grant is the state will provide the grant.
Yes, my
Please.
lords.
So what have they done?
No, they did, they approved the appointment, paid not the salary only from the date the appointment was approved.
Whose
That's-
appointment?
That is the appointment of the petitioner.
son.
Yes, my lords.
Now what, from which date the single judge has given?
My lords, from the date he was originally appointed by the institution.
Who?
My lord, that is 10th
Lords.
June 2001, my lord. He was appointed by the institution, my lord. Government approved him for the grant in aid on 3rd January 2009.
And
From
father died in?
father died on
18/5/1996.
96, my lord.
And when did he get the compassionate appointment?
My lords, that was moved immediately, my lords, in 2001. He was, my lords,
There were
appointed.
3 occasions, my lord, where the recommendations were made by the management, my lord, for
But
different
tell us
posts.
one thing.
Please, my lord.
Father was getting the grant on which post? On the post where he was working. He gets a compassionate appointment. So the son, he is appointed on a particular date, 2001, I suppose.
Please.
So will it not be against the post vacated by the father that he should
My lord, that
be given?
came towards the end, my lord. There were 3 proposals from the management, my lord. Earlier, he was recommended for the post of senior division assistant, my lord. That came to be rejected on 2 occasions. Ultimately, my lord, an order came to be passed for approving his appointment for the post of attender. That was in 2009, my lord. The issue, my lord, whether he is entitled for arrears, that original appointment is made by the institution, my lord. Approval came subsequently. As per the rules, my lord, it is from the date of the approval, he is
But tell us one
eligible
thing.
for the grant in aid salary, my lord.
But tell us one thing.
My lord, this issue, my lord, whether he is entitled for the pre-aided prior to the period, prior to the approval, my lord, there are connected writ appeals that are pending, my lord.
We'll tell
The
you.
Same issue.
We'll tell you. Possibly you can distinguish.
Please, my lord,
Principally, grant is allowed
for the post,
for the post because father.
please.
It's not a fresh appointment of the son.
Correct.
Nothing connected to the father, nothing. It's a fresh appointment. He is appointed by an institution. Later, it is approved by the state government.
government.
From that date, it will be given, possibly no
That
issue
has been
on that.
given also, my lord.
But in this case, since the appointment follows the death of the father, and it's for compassionate appointment, and there is a purpose for compassionate appointment, why should not be given from that day?
There is the period between 2001 to 2009, my lord, when the
But why did you
management
take
of
so
the-
much of time?
No, my lord, institution, my lord, there's a series of correspondence, my lord. There were 3 proposals, in fact, rejected on previous occasions because it was not for the post which the father was holding. They had sent it for a different post altogether, my lord, on the previous occasions.
What is the difference between the salary the institution was paying and the grant?
My lord, I have to verify on the amount.
How much is the
That's
difference?
very meager, my lords.
How much?
Hardly few hundreds, my lords, he was paid.
Few hundred, 100 or 200?
Around 500, 600 rupees.
But you said, you see. See,
But what
the
happens-
difference is
No,
not
my lord,
much.
it may be few hundreds in this case, my lord, but it will be a precedent, my lord, for other cases.
Tell us one thing, is there any case, are there any cases where a person gets a compassionate appointment, he is given grant salary?
I have to verify, my lord.
That's
I'm not
all.
sure. There's a batch of matters, my lord. I will get it verified if compassionate appointment is an issue in those batch matters.
Do that. If they are not, those are on a different grounds.
Different footing, then
Exactly.
it has to be
These are on
decided
different footing.
differently. I'll verify that and get back. my lord.
Just say at
In
the
this
request
case,
of-
it might be few hundred, my lord, but it should not be a precedent, my lord. We will take.
But the distinguishing feature would
Yes, I
be,
understand. my lord.
is a grant in, see, otherwise, what is the purpose of
I
compassionate?
understand, my lord. The grant is for the post that has the father held in.
Oh,
Yes.
grant is for the post father
Yes.
held,
Please.
and there is no grant here.
My lord,
The
she
approval
is
came in
approved.
2009 for the specific post held by the son. That's the slight difference, my lord.
He is trying to make a distinction.
Please.
The grant is to the post on which the gentleman was working.
Holding.
My lords, I am afraid it is not correct. Section 49 of the Karnataka
Okay,
Education
we
Act
will
says,
see, re-notify.
My lord, it says, my lord, it is to the institution the grants are extended, not to a particular post.
No, it's,
That's
for-
what, my lord, the.
We'll see that. We'll see that. Now, today you are working,
My lords, I am
you're
working.
earning your salary.
My lords, I am,
Continue.
my lords,
Next.
the connected appeal copy, my lords, is not served on me, my lords.
I'll
if they
serve
do.
on then, my lord. Notice has to be ordered.
Which one?
The appeal which is
64.1, my lord, that's the state government appeal.
It's a fresh matter.
Yes, my lord.
Notice, just say notice, Mr. Srikanth, accept notice for one. Delay, you have any issue?
My lords, I do. my lord.
Okay, list the contempt and the delay and the writ appeal on.
18-8,
Published.
Publish.
65 adjourned. 66, Shrivas Nayak. 66.
None for the petitioner, none for the appellant, adjourned to.
20th August, 67. 67,
None for the appellant, adjourned to.
20th August, 68.
Raise 3 weeks time for additional.
At the request of the counsel for the appellant, adjourned to.
19-8, 69.
Very short point for consideration.
Ma'am, you have you filed your reply?
They are seeking for a direction from the government with regard to grant of alternate land since the land has been granted to them for, carrying on quarrying, will not come within the tiger reservation area. So now they are, as per 156, they are seeking for alternate land. Now I have to get instructions from the government with regard.
May I make one submission? Not my
Just show us the file. ma'am.
grant is not a grant in the usual sense under the act. It was a auction come sale. But as per the auction come sale, under the rules, I am entitled for 2 renewals.
Entitled
2
to
renewals.
2 renewals.
Renewals. So I applied my first renewal. I got between 2006 and 2013. My total extent of the auction was 29 acres. Out of which, Lord, they could not give me the entire extent because there were no mineral in most of the land. So they gave me only 12. And there is an order by this honorable court that for the remaining, they'll give me an alternative area. There is a purpose why I'm submitting this. So this order was passed way back in 2000 and the government went all the way to Supreme Court and that single judge's order got confirmed that I'm entitled for an alternative area. That is insofar as the extent 29 minus 12. Now, Lord, 12 I worked. From 2006 to 2013, I worked in 9 because 3 they couldn't give. They issued a corrigendum that they will give me another area. This is one part. Now, on the 9 acres, I have another right of renewal. By then, an amendment came to the KMC to say I'm entitled for a deemed extension for 30 years. So, I am equipped with a right for renewal. I am equipped with a deemed extension. And I am beyond 2 kilometers from the boundaries. Now they have chosen to extend it beyond. But that is their prerogative. All I'm saying, give me another land. That's all. Give me somewhere else.
No, what did you say? The last one, they have decided to extend?
Beyond 2 kilometers. They say they want to declare the eco-sensitive
You also
zone.
want that way?
No,
You don't want that way?
No, I have no say. I only want to work in the
That's right.
Now, I'll read.
So what you are saying is principally they have agreed to give you?
Principally, they have agreed to give you. Legally, I have a right. In my own case, there is directions to give me alternate area. And 2 occasions they took
And
time.
you say there is a deemed extension?
Deemed extension also. So I say deemed extension was for this area. No, you take away my right and you declare it eco-sensitive. Then at least that I have is to give me somewhere else. You can't say I won't give you that.
How long
Lord,
will
this
it
is
take
what
you?
is happening from the past 3 hearings. So Lordship may.
Will Banda ma'am tell us, we'll reply.
No, my lord, may grant me 6 weeks time.
Why 6 weeks, ma'am?
My lord, because alternate land is what they are seeking for. My
That's
lord,
right, ma'am. Did you take time to file reply earlier?
Yeah, my lord.
But why no reply?
My lord, on the last date of hearing, my lord, the Chief Justice had put this across. I put it across to the government. My Lord may grant us some time because this will set a precedent in other matters also. Lord, it will set a precedent when there's.
Precedent, no, we are not, see, we are not on the merits. We are only on the reply, that's all.
My Lord, that is what one reply in one matter will set a precedent.
But then we will say so, we will say so as an outer limit, you will file it within 6 weeks. They should be, man, they should be. They have filed it.
My Lord, if the government says yes, then I will file a memo to that effect. My Lord, I have to.
Just
get a
1 minute,
reply.
just 1 minute. You were 18(3), you were directed to take instructions, apprise the court about the policy of the government in that regard.
Yes,
Then matter deferred to 8(4).
yes, yes,
From 8(4), we are here today.
yes.
Your 7-3 also there is a,
Pardon?
7-3 also it had come and they took time and then it went to.
Okay,
thereafter
just say that
8-3.
Leonard, the counsel for the respondent seeks and is allowed 6 weeks as an outer limit to file, to take instructions and file counter affidavit. You have replied to this counter affidavit. Okay, and the same is the next one also.
No, only
Different,
this one.
different. Okay,
7-8,
re-notify after 6 weeks.
7-8. Serial number 70,
Obligation.
70.
On behalf of Advocate for petitioners, my lords. The issue challenged in this writ petition has been under review before and appeal before this Honorable Apex Court in Udaipur Chamber of Commerce. Whether royalty paid is a consideration.
Just say this at the request of counsel for the petitioner.
Please, my lords.
Adjourn to.
21-8,
Obligation.
71 adjourned, 72. 72. Shri Gautam Devula.
Here for the respondent to.
Yes, Mr. Hegde.
My lords, the order of transfer was challenged before the learned single judge. Learned single judge might say allowed the writ petition. We are aggrieved by that order, my lords. My lord, the order of transfer is 1207 and 1207/2024, my lords. That was withdrawn by the same department, my lords, Bangalore Electricity Supply Company Limited on 31st July 2024, immediately withdrawn. Now, what the honorable learned single judge holds, my lords, is that the transfer cannot be withdrawn. Number one, the reasons assigned why it's being withdrawn. Detailed reasons are assigned, my lords, why it's withdrawn, and in the statement of objection they justify the.
You appear for the respondent.
Respondent 2 to 4, my lord, for the department.
2 to 4.
Yes.
Department has clearly said, my lords, the justification for withdrawal of the transfer. My lords, once an order of transfer, my lords, it's withdrawn during the said period only. There is a particular period within which general transfer could be effected, my lords. And very serious allegations are against the concerned transferred employee. Therefore, they did not want him to be transferred to a sensitive place.
Where were you transferred?
Now, my lords, I am the person, my lords, who is affected by the impugned order of transfer and recall.
In Bangalore. This is within Bangalore.
No, it's within Bangalore, my lords. As far as I am concerned, my lords, my grievance is against the order of the honorable learned single judge, my lords. The learned single judge, my lords, learned single judge has set aside the transfer order. I am aggrieved by the order. Order of transfer has been set aside.
Though it's in your favor.
No, my lords. I am a person. I was holding one post. The writ petitioner was posted to my place.
Who are you?
And my lords, I am a respondent.
Respondent number 4.
Respondent number 4, my lords.
Okay.
Respondent number 4. Kindly see page 64 for a moment, my lords.
Were you a respondent?
Respondent number 4, my lords.
You are respondent.
Please.
And the petitioner who approached the learner single judge.
Has succeeded.
There were 2 petitions filed.
One is, my lords, only to consider his representation. Okay. And that both were clubbed together, taken up together.
So what was your challenge? You challenged your transfer.
No, I don't, my lords.
Raju.
No, I am Raju, my lords. L. Shankar, who has been transferred. My lord, what happened? L. Shankar was transferred to my place.
What is the place name?
Hesrugatta to Kanakpura division, my lord.
From where?
From Hesrugatta to Kanakpura.
Kanakpura division. And that is,
Gatta to
storekeeper.
Storekeeper to Kanakpura.
Kanakpur.
One is important, lords, may kindly note, my lords.
Mr.
It is
L. Shankar has been transferred.
Shankar.
And what about Raju?
Raju was transferred to the place of,
From Kanakpura to Esrugatta.
Acha, it's
The
a reverse.
Yes.
is reverse.
Say swapping.
Then this order, my lords, after some time, they find that an inquiry is pending at L. Shankar, and the post to which he is now transferred is the storekeeper post. There is already allegations of misappropriation pending against him.
Against whom?
Against him, L. Shankar.
And what about you?
No inquiry, nothing, no case against me. So what they did was, they recalled that order immediately. 31st, they recalled the order and assigning reasons.
From store.
The same order is recalled and restored. Previous position is restored.
So he went back to
Yes.
Harshit.
Effectively, my lord,
Gatta.
yeah, order of transfer which is issued is recalled, assigning the reasons. And the statement of objection, they assign many reasons, inquiry is pending, all those things. We did not want him to be in the sensitive place, therefore recalled. Now the question is this, my lords. The order of transfer having been issued, can it not be recalled is one question, my lords. And what grounds it can be challenged? Now the honorable single judge, my lord, with great respect holds, my lords, the principle of natural justice should have been followed, and that could not have been recalled, etc. is the reasoning, my lords. My respectful submission is,
What happened to Raju?
the same, they restored the original position, my lords.
For him also.
Him also.
For Shankar also.
Some are also. That,
What is the grievance then?
the grievance is this, my lords. Now, my lords, if they assign the original position, we have no grievance, my lords. What they did was, my lords, original transfer order was recalled. The recall order is set aside by the honorable learned single judge, my lords.
So both are at their transferred positions.
Transfer order, though the government says, no, we don't want to effect the transfer order.
But the transfer orders have been restored.
Transfer order has been restored, which in effect against the departmental.
Though the department has withdrawn it.
Which is totally illegal, my lord. Now, this honorable court and the honorable Supreme Court repeatedly held, my lords, the transfer order is concerned, or recall order, etc. These are all discretion orders. How can it be, my lord?
Ma'am, tell us one thing. You appear for whom?
I'm up here for the respondent 2 to 4, my lord, for the
The
department.
employer.
Yes.
They justify their orders. They have justified, filed a detailed statement of exemption. Inquiry is pending. Several lakhs of rupees, please.
You withdrew that orders?
My lord, 12/7/24, the general transfer order is passed, my lord. On 31st/7/2024, we withdraw the 12/7 and we stated to go back his original
Respective
place.
places.
Respective places, my lord. This order has been challenged by the petitioner, my lord, and it is set aside.
Now, what are the allegations against L. Shankar? Are there any allegations?
My lord, there is a departmental inquiry pending against the
What
L.
is
Shankar, my lord.
what is the charges?
Misappropriation, my lord.
Then why did you post him?
Because of after the verification, soon we withdraw his transfer, my lord, on 31st/7/2024.
So today he's going back. Shankar has gone to the store.
Yes, my lord.
Has he been posted?
Yes, my lord. Now
He's working there.
Yes, my lord. We need to get instruction. The present where he's working, my lord, he is transferred to the Hesrugatta.
Because, my lords, we could not get any interim orders, my lords, because they said notice has to be issued. There was caveat, etc.
There cannot be anything, Mr. Egde.
That's
Interim
right.
order. What will happen? Even Raju will go to the same place where
Yes.
Shankar is working.
Please.
Create more confusion.
No, my lords, as far as my lords, one question, my lords, it's my duty to inform the honorable.
Appearing for Shankar.
Srinivas, my lord, advocate. Yes, no.
Earlier also twice, my lords, the matter come, they did not, because there is there is no interim order. They have already occupied that post where there is already an irrigation. And your lords may also take judicial notice. This from the electricity department. Yes.
Managing director will pass the order. Then they'll have
The
to
statement
take
of petition, statement of petitions filed by them. Kindly see page, please. Page 186. Page 186 with kind permission, please. Honorable 186 of the statement of objections, my lords. Alva. Yeah. 186 in writ appeal number, my lords, 81 of 2025. May I pray the kind consideration to page 186.
When the order was revoked, transfer orders, did Raju went back to his original position at Kanakpura?
First order was issued, no, my lords. First, no, my lords, I was working in Kanakpura as a storekeeper, my lords. That order, I was transferred. I did not,
You did not join?
no, I did not join because my lord is recalled immediately.
No, but when the order was withdrawn, you continue to work there?
Yes,
at
because my lords,
Kanakpura?
short duration was very short, my lords. And in the MESCOM department, electricity department, my lords. Please, one more aspect in the electricity department is, my lord, they say orders transfers, the general transfers.
Where are you working today?
Now because of the honorable single judge order, my lords, I have been transferred.
To where? This place?
Hesargadda.
Hesargatta.
My lords, the question is this, my lords, page 186, allegation of shortage of materials during the time of Shankar, serving as storekeeper at so and so division, 10,92,000. Case is pending.
He is the counsel for L. Shankar.
Srinivasa K.
Our fear is some more shortage in electricity.
This Shankar is working at Kanakpura
Yes, my lord. As per
continuous
the,
because of the order of the learned single judge.
yes, my lord, he is working in Kanakpura.
But has it not been suspended when you are holding a departmental inquiry?
My lord, due to the departmental inquiry, my lord, from he was working in Nenmangla, then he transferred to
How many
Hesrughatta.
times?
From the, in the general transfer, my lord, in the general period, it was
Again.
transferred to Hesrughatta to Kanakpura. Later, we get to know that there is a departmental inquiry, so we withdraw that earlier transfer order and give back to his to.
That inquiry was in respect of a conduct which was at.
In Hesrughatta. Originally, he was as a meter reader, my lord. Then he promoted and working as in Hesrughatta only.
And now
From Hesrughatta to,
you want to retain him in Hesarghatta only, though he has conducted.
from the Nenmangla to Hesrughatta, due to the
Where
department,
did the misconduct took place?
Nenmangla, my lord.
ಅಲ್ಲಿ ನೆಲಮಂಗಲ ಏನು ಪೋಸ್ಟ್ ಏನು
Hesargatta
ಪೋಸ್ಟ್
he
ಏನು
was working, he was transferred to Kanakpura.
ಪೋಸ್ಟ್
That was general transfer. Misconduct took place in that one.
But anyway,
ಪೋಸ್ಟ್ ಏನು ನೆಲಮಂಗಲದಲ್ಲಿ
to Hesargatta. Continue. He was suspended and
Then what is the reason for again?
Earlier he was in non-executive, my lords, because of inquiry proceedings. Now again made as a storekeeper. That's all the difference.
What are you
I
saying?
failed to make that point to the kind consideration. Yes, yes. Case 185.
as a store assistant.
Yes.
Additional document.
Page number
Executive.
786. ಅದು 21 lakhs.
Have it after week or so. We'll have it next week. Let's see if someone
Please.
comes.
Why? My friend says there's one more case of 21 lakhs 26,000, my lords. That's why.
Say कि transfer order he should have, no, the justification given by him is since he stood relieved, he should have been given a show cause. What are they? This is only a posting order. At the most posting order. Just say that there is no appearance for respondent number 1 in the interest of justice. Adjourn 2.
They pray for an earliest possible, my lords. I know the for my lords, please.
Just give it, ma'am, date, any date.
24/7.
May I humbly pray, my lords, since
Next.
he will continue duly to go. In this 1 week after, my lords, he is not appearing, he's not in channel. If he's not appear, doesn't appear means he will continue in the same post.
1 minute. The employer has not come in appeal.
No, he had put the grievance in writing,
The-
statement objections.
The learned judge has set aside.
Please,
Who should be aggrieved?
your lords may only take judicial
should be
notice
aggrieved.
how the posts are given,
And
my lords.
So when there are serious charges against the gentleman,
No, my lords,
and
this-
more so when they withdrew the transfer order, still they don't come.
your lords may see why it is not being done. That's in the electricity department.
The appellant have not contested in the writ petition, my lord. Though they have served, they have not contested in the WP. The
Who?
present appellants, my lord.
Pardon?
The present appellants did not contest in the writ petition, my lord.
Why did you withdraw?
My lord, due to the departmental inquiry, we withdraw.
Departmental inquiry was in Nelamangala.
Yes, my lord.
At Hesaraghatta, there was nothing.
He was posted at Hesar.
From the, due to the departmental inquiry, my lord, we transferred from Nenmangala to Hesrugat.
Was brought here because of inquiry. Yeah, they realized that. Then they withdrew it. But you should, the employer must
My
come.
lord, as per the
Why the
condition,
employees are fighting against each other? The employer must come.
my lord, as per the condition, my lord, in the page 94, there's specifically clause 2 is there, if there is any pending inquiry against the transferred employee, such,
Right. You realize there is an inquiry, that's the reason you withdrew it.
yes, my lord.
But now the learner single judge has set aside, you should have come. Okay.
You are
Then give
kindly
it-
recommend next week, my lords. Other this way or that, otherwise, this will allow him to graze further. This is happens.
Just give it, ma'am, after 10 days.
And
After 10 days, give it.
please, please.
Next.
Great.
9/7. 73. 73.
May please your lordship.
Yes, ma'am.
My lord, the annexure A is the order passed in writ petition. It is page at 16 to 32. 16 to 32.
What was the direction?
Direction, my lord, to consider the representation given by the complainant regarding repair of the house, dwelling house, which has fallen down.
They did not do it, consider it.
Not consider it, and she says that there may be an order from the High Court, but we cannot give the permission.
Issue notice.
May I request one thing, my lord? My lord, kindly direction may be given to that particular officer. Even earlier case also, there is a structure passed by this honorable court. Maybe directed her to be present before your lordship. My lord.
We will see it, ma'am.
Much of.
Issue notice.
12/8. 74.
None for the parties adjourned to.
20th August. 75. 75.
None for the appellant adjourned to.
20th August. 76.
Yes.
Party
Your Lordship,
person.
this is a civil
Happened.
contempt. They're neither moving their MFAs, it's not getting listed, and they're not even showing the child to me. It's almost 3.5 months from the date of family court order.
Just say notice.
The habeas corpus
notice-
was urgent
notice issued
stating-
in this. Amma, Ajay, show us.
Kindly submitting a memo,
Ma'am,
kindly
what is
permit me
this
to.
order, ma'am? Notice C form issued. Okay. What were they required to do?
They have to share the custody of the child with me. It's a shared parenting order wherein I was entitled for about 45 days of vacation, summer vacation holidays.
Where
and
is that order? Show us that.
It's from page number 13, the order starts. And page number 136, my lords.
133.
136, order starts. The petition filed by the petition under 6 and 13 of the Hindu
Which is the
minor.
direction which you are seeking implemented?
This order of the family court, final.
What was the direction?
It's here, my lords, in the final.
Let's say that issue notice.
Kindly permit me to allow hand summons. I am submitting a memo.
And
Hand summons. For hand summons,
including hand summons.
so that I can get it listed.
Issue notice including hand summons for service on the respondent returnable on.
May I get a date, my lords? This,
28/7.
no, this next week at least. I'll serve the copies
Just
immediately.
give it, ma'am. I think.
Next week, 23rd or 24th.
30th, give us 30th.
No, my lords, 23rd, 24th.
30th.
30th
Obliged.
June. 30th June. 77 urgent, 78.
My lords, I'm appearing for the petitioner in this case. My lords, we're ready to argue this matter. We require about 30 to 45 minutes of time, my lords. A
We
date
will
may
have
be-
it some other day.
Please, my lords.
We
A date may
notify.
be-
14/8.
Much obliged.
79. 79.
None for the petitioner adjourned to.
18/8. 80. Seal number 80.
These are to be argued.
My lord,
My lords, in the connected matter, still order, notice is not been ordered, my lords.
We'll have it some other day.
My lord, it may be adjourned by at least by 4 weeks, my lord. The reason is that, my lord, the matter is under settlement, my lord, under settlement talks before as the Supreme Court judge, retired Supreme Court judge, as per the order of the
Justice
Supreme Court.
Sanjay Kishan Kaul is been
And we are not
appointed as a
proceed-
mediator by Honorable Supreme Court, my
Who?
lord. Justice Sanjay Kishan Kaul, my lords.
Okay. Just say joint request adjourned to.
Yes.
Okay.
My lords, in the meantime, notice may be ordered, my lords, in the connected.
Let's see if joint request adjourned to. Next.
28/7.
Pass over.
Store matter serial number 3.
Tell us court fee.
Court fee is
Ma'am,
paid,
how
my lord.
much is that? The same is sufficient. So what did we do in the morning?
The respondent had submitted that there is no objection for the appeal to be allowed because the matter is.
We'll
listed for-
continue the interim order and
Yes.
we'll ask them to dispose of.
Yes, my lords, that is my limited submission.
Yeah.
Matter is before the trial court on 23rd of June.
So-
A direction may be given that within 2 weeks it may be disposed of. We'll argue the matter there.
Just take this, ma'am. This appeal has been filed challenging the order dated 29/4/25 passed by the so-and-so, whereby the learned trial court has dismissed the IA 16 filed by the appellant herein. Appellant herein. Gustav. Appellant herein. Suffice to state that on 10/7/24, an interim order was passed by the trial court. Where is the 10/7/24?
It is at page 73, my lord.
Whereby
Excellent.
an injunction order was issued against the respondent, injuncting the respondent from using vehicles leased from the appellant herein. That's right, appellant herein.
Yes.
Till the next date of hearing. It appears that the interim order was being continued from day to day, on every date of hearing. Until the impugned order was passed on 29/4.
The interim order is continued till 12/3, my lord. 12th of March, page 90, my lord.
Page
90, 90.
9 or 90?
90, my lord. From 10/7/24 to 12/3, my lord, the application for extension was not filed.
Until the matter was finally heard on 9/4/25.
No, my lord, page 90, 12/3/25, it was reserved for orders.
Acha,
The
until 12/3/25, when the petition was heard. You call it petition or what? You call it?
Application, my lord.
Huh?
Arbitration application.
Arbitration application was heard. First. Then what happened?
Lord, on 15/3, I've moved an advancement application.
First, as there was no extension of the interim order on 12/3/25, the counsel for the appellant filed an application being IA 16, which was under section 151 CPC, seeking extension of the temporary injunction. Full stop. Temporary injunction. Full stop. It was the said order. It was the said application which was disposed of by the impugned order on 29/4/25, whereby the trial court has rejected the application being IA 16 of 2016. Full stop. The learned counsel for the respondent who appears in the proceedings would fairly state that she has no objection if the interim order passed on
10/7/24.
10th of July 2024 is extended till 23rd of June 2025. When the proceedings are pending.
Pending for main hearing on merit.
Final argument.
Final
On,
argument.
for final argument, when the arbitration application is pending for final arguments.
Yes, ma'am.
Full stop. She also states that the continuance of the interim order shall depend upon the outcome of the arbitration application. Full stop. The submission of the learned counsel for the respondent is agreeable to the counsel for the appellant. If that be so, we dispose of the appeal continuing the interim order dated 10/7/2024 till 23rd of June 2025. No, till such time, don't say 23, till such time arbitration application is decided by hearing the counsel for the parties on 23rd of June 2025. Okay?
2 weeks, a direction may be given to the trial court to dispose of the matter within 2 weeks.
Okay. That should be within 2 weeks. 2 weeks effective from 23/6/2020. Okay.
Great.
Appeal disposed of.
Great.
Thank you.
21, Subramanya.
For the complainant.
I've been told DC admin is the person who's in charge of this, my lord. May I request, my lord? Lord, there are also writ appeals filed by BBMP, my lord, and the agreed parties in the writ petition, my lord. That is one of my submission, my lord. That is all pending before this court, my lord.
So what were the directions given?
Lord, may I request, my lord? Para 82, the direction starts from para 82, my lord. May I read start from para 82, my lord. Lord, first question would be the answer in favor of the petitioner, promotees, and it will have to be held that the quota rule had not been followed continuously for 31 years.
Tell
and
us what has to be done.
my lord,
Direction.
what the single judge has said, my lord, to redo the list. To redo the list, my lord, but there is no time limit fixed, my lord. For this, my lord, the
Or
Supreme.
is there any stay in the appeals?
No, my lord.
No, my lord. No stay has been filed, my lord, and moreover, the writ court, my lord, has not even stated.
When are the appeals listed?
My lord,
Previously it was
it's still under
listed in-
office objections, my lord. There's some translations which will have to.
That's the reason, obviously, then she will definitely insist upon the order to be complied.
Yes,
If
my
file an appeal, then
No, my lord, that's not the reason, my lord.
obviously, when did you file the appeal?
Lord, this is filed in 2024, my lord.
Just imagine.
Yes, my lord.
Just
I do not
This we will
Moreover, my
not.
lord, may I
This we
request, my
will
lord,
not.
there are two
Yeah,
judgments
you
which
see,
I.
I'll tell you, we don't understand. A litigant comes to the court after much thinking, whether I should go or whether I give a representation, my grievance can be sorted out. He comes to the court, the litigation takes some time. Finally, directions are given, allowed. Those directions are not complied with. Contempt file, appeal filed by you, it is not get listed, and they are contempt seeking execution. See, everything is really, what is the use of a litigant coming to the court?
My lords are right, my lord, but
See, for the sake of opposing a matter, or you don't want
no, my
to
lord,
give effect to that,
my
you
lord,
file an
dispute
appeal.
is between direct recruitees and promotees, my lord. My lord, now the single judge.
It's a huge litigation between direct recruits and
Yes, my
promotees. We don't want to say it. The delay would inure to one of the side.
Yes, my lord. Now, my lord, the agreed person in the writ petition will also file a writ appeal, my lord. There also the
The
notice
employer
has
has
been-
come.
Yes, employers also filed and writ appeals, my lord. There are series of writ appeals filed.
We will just adjourn it, but with a clear understanding, you get your appeals listed.
Yes, my lord. Moreover, my lord,
We don't want.
may I
Just say
request, my
that
lord, if I
Telangana
may
counsel for the
produce two
respondents take-
judgments of this court. Two judges, one judgment of the Supreme Court and one judgment of this court, which has been followed, where it says, my lord, where there is no time limit prescribed, my lord. Where there's no time limit prescribed, my lord, there's
Let's
no
test that
contempt.
argument.
There's no
How many
contempt.
years?
Lord,
And we will tell you minded when there is a time limit, thumb rule is 6 months.
my lord, that
How much that judgment says?
no time limit is prescribed.
There are judgments which say 6 months. No
My
time
lord.
limit. And how many months we have crossed?
Lord, 1 year, my lord.
Just say that at the request of counsel for the respondent, we adjourn it by stating, just say that by stating that the employer, respondent employer has also filed an appeal of which compliance is sought, comma, which he shall get listed for hearing, within 4 weeks, re-notify.
Much obliged.
It's a shorter date, my lords.
Pardon?
I
We'll have
agree.
it after 4 weeks, ma'am. We have to have after
My
4
only
weeks.
submission is some of the petitioners are already nearing retirement, my lords. If
Well,
it
it
is-
doesn't make any difference. If you succeed, you will get it from a back date. Once a right has inured or accrued in your favor, it will continue. Even though they may not succeed, you will get it. Give a date after 4 weeks.
6/8,
Much obliged.
22, serial number 22.
Appear for the petitioner, my lords. This is a matter in which there was an order not to create any
For a
further
week time,
third-party rights, whereas the contemner has continued to be in
Yes, tell
violation
us.
of the same,
This is, what do you say?
despite our
For a
contempt
week
notice.
time, my lord. For a week time, my lord, we'll argue the matter in the next day of hearing.
Is it your case that
Well,
he did not
in
violate
this-
the interim order?
Some of the persons who had executed are not at all made parties. Both
Forget
in
it.
appeal
Who
and
has been made a
even-
party?
He is a party, my lords.
This gentleman violated the order.
And at least
We
kindly
will
have
call him.
tomorrow, madam. Tomorrow,
We will call him.
tomorrow, madam.
See, there is a clear-cut order.
Even he is also not made party, madam.
Page 20, my lords. 25 is the operative.
25.
Yeah.
Not to create third-party rights. Not to create third-party rights. So what, did he create third-party rights?
Today I am not prepared, madam. May I kindly have
Did you file reply?
They
I have
filed
filed
a-
What did he say in the reply?
In the reply, my lords, they have said that they have entered into a JDA with one Jayalakshmi who is not a party to the 737 suit.
She is not party, madam. She had individually executed, said it, madam.
My lords,
How
they,
did
Her
she
individual
get the
capacity.
share?
By way of gift, my lord.
From whom?
From his husband, from her husband.
who is a party to
Who is the
7
husband?
He is a party. During
lord,
2013, my lord, by that time,
Not like this. It's trying to overreach.
Irrespective, my lords, they are named as a purchaser in each of the sale deeds that I have produced here.
the gift deed is of 2013, my lord.
Who were the parties on whom the interim order was binding?
The contemner, my lords. He was a party as on
How
date.
do we get that?
Uh,
Come to page 20.
Please, my lords.
Where is a party?
He is respondent number 24, my lords.
And what is his name?
DS Max. Through the company, he's represented through the company. Page number 30, my lords, is the MFA.
This is your suit.
It's an MFA arising out of a suit, my lords. The MFA is pending before this honorable court,
Where the interim order was passed.
where the interim order was passed. Page 30, he's named as respondent number 24. DS
What about
Max
others?
Properties.
Did others also violated? No.
No, my lords. To our knowledge, to our best of our knowledge, it's only defendant number 24.
24.
He's created an apartment on the property, my lords, the subject property, and he's sold apartments despite our contempt notice. We only got, the interim order was passed in March of 23. We sent a legal notice on October 23. He's continued beyond that to issue sale deeds to.
Next week, no candidate.
How do you reply that?
That will argue, my lord.
Call him.
What is that? What is your defense? Tell us first. What you are going to argue?
Just say that we have heard the counsel for the parties, comma, the respondent shall be present in the court on the next date of hearing. Give it in August.
14/8.
Obliged, my lords.
Over, ma'am. Over. Come.